that are going to be joining us today are now signed on, so I believe we can go ahead and get started, Mel.
Okay, thank you, Bert. All right, I'll get my camera turned on here. Okay, excellent. All right, well, good afternoon, everybody. We'll go ahead and call this hearing to order. Welcome to the monthly meeting of the City of Des Moines Zoning Board of Adjustment. My name is Mel Pins, the board chair. I want to welcome everybody here this afternoon. I'm only going to have my camera on just for this limited introduction here, so I can welcome everyone and give you the background on the proceedings for this hearing. Then I'm going to turn my camera off so we can save on bandwidth, so that we can ensure everybody gets a quick connectivity as much as possible here. This board has power under Iowa law and the zoning ordinance of the City of Des Moines to hear and make decisions on requests for variances and exceptions from the regulations in the zoning ordinance, conditional use permit requests, as well as appeals from any decision of the city staff in the administration of the zoning ordinance. The members of this board are citizens of the City of Des Moines and have been appointed to the board by the City Council. The board members are volunteers and receive no compensation for their public service. I'm going to go ahead and introduce our board members today. I believe we have 6 of our 7 members present today. Is that correct, Bert?
That is correct. Nathan Blake was unable to join us this afternoon.
Okay, so our members present today are Cindy Smith, Marlis Jones, Lynn Carlson, Dave Gare, Justin Gross, and again, I'm Mel Pins, the board chair. I'll also introduce or refer to our city staff who may be assisting us today. They include the Board of Adjustment's legal counsel, which is Judy Parks Cruz. Representing city staff are Bert Dross, city planner, Eric Lundy, city planner, Jason Van Essen, city planner, Catherine Drejas, city planner, Sue Ann Donovan, zoning enforcement officer, Michael Ludwig, planning administrator, and Tyler Hall, our meeting moderator. I'm going to cover the meeting's procedure briefly, and for those of you who are watching and listening, we will help you through this process, so don't worry about that, but I'll go ahead and give the background here so we can kind of get everybody situated. This Board of Adjustment is a quasi-legal board. This hearing will be conducted within the procedures and format as authorized by Iowa law and this city's ordinances. This meeting is open to the public. The meeting is being recorded by both audio and video for a legal record of these proceedings. The board members have each received a copy of the agenda and the staff recommendations. The board is required to base its decision on each item based upon the criteria established by law for the type of relief sought by the applicant. The law applicable to each case is identified in the written staff report. If the facts, as determined by this board, demonstrates that the criteria established by law for granting the relief have been satisfied, then the board must grant the relief. Otherwise, the board must deny the relief. Each item will be announced in the order that it appears on the agenda. Items listed on the consent portion of the agenda, which is our first portion of the agenda, are not planned to be individually discussed at this time. They will be considered for approval in accordance with the recommendations in the staff report, unless the appellant does not agree to the conditions recommended by staff, or if there's an individual or a board member that requests the item be removed from the consent agenda so that a full discussion on the matter can occur. And I will come back to this as we review the consent agenda. So if there's anybody that wants us to consider any item on the consent agenda for direct testimony, we can do that. On the agenda, after an item is announced for the general hearing, city staff will first give a brief overview of the appeal, and they will present any written comments that have been received prior to the hearing. Then the applicant or their representative will be allowed up to 10 minutes to present the reasoning for their appeal. We will then move to the public comment portion of the hearing. Anyone wanting to speak in support of, in opposition to, or even in neutrality related to an appeal will be allowed up to 5 minutes each to provide their comments. This will be their one and only opportunity to address the board on that item. If you wish to speak on the item at hand, when the chair calls for public comments, please click the raise hand icon on the participants panel if you're participating by Zoom, or press *9 on your keypad if you're participating over the phone. The meeting moderator will then know to call on you. When it is your turn, the meeting moderator will unmute your microphone and acknowledge you to proceed with your comments. If you are participating over the phone, once you're acknowledged, you must then press *6 to unmute. Also, you must email any documents that you need to use in your presentation today to planning@dmgov.org. Again, that's planning@dmgov.org. That is, if you have not already provided those to city staff prior to the hearing. And again, for recognizing folks at the appropriate time, I will go through that. We'll give everybody reminders so that they can provide their testimony as appropriate. Once all concerned citizens have spoken, the board will then ask any additional questions of city staff. And lastly, the applicant will be given 3 more minutes for rebuttal or other closing comments, if they so choose to do so. All speakers are required to begin their presentation by first giving both their complete name and address of business or residence. This is so that in the event you may need to be contacted for legal notices related to the outcome of this appeal. All speakers are requested to remain courteous and to focus their comments only upon those facts that demonstrate whether or not the criteria established by law has been satisfied. Speakers are asked to ensure that they are respectful of time considerations, and if necessary, the board chair will limit further comments by a speaker if they exceed their time limitation. The board will then close any further public comment on the agenda item, and the board will immediately deliberate the request, and we will make a decision on the appeal here today. Please note that it takes at least 4 affirmative votes for any zoning appeal to gain approval. If your appeal is approved today, we ask that you wait until at least 1 week from today's hearing to contact the city's Permit and Development Center if you would need to obtain any necessary building permits or sign permits related to your appeal. This will allow the decision of the board to be documented in the form of a decision and order, which will be provided to you and city staff. Any appeal that is approved by this board must be implemented, constructed, or otherwise utilized within 2 years of the date of the decision by this board, or such approval shall expire. The decisions of this board can only be appealed in the Iowa District Court. If you believe you've been harmed by an error made by this board, your only remedy is to seek relief through the court within 30 days of the filing of the board's decision and order. If you believe the zoning regulations applied by this board are wrong, you may petition the city council to change those regulations for future consideration. All material written or otherwise used today as part of any presentation is part of the permanent record. You may contact city staff after the hearing if you may need a copy of such records. Also, we ask that you keep your microphone on mute other than when addressing the board to limit distractions during the hearing that is in progress. We also ask that you refrain from using any chat or question and answer function as part of the Zoom meeting, as that conferencing function will not be monitored for response, and the use of that function could be construed as an ex parte communication outside of the hearing process. So that's the background on how we'll conduct the hearing process today. And again, we'll work all the applicants and anybody that wishes to respond to the applicant through each step of this. So the first thing we'll do here is I'm going to turn it back over to Bert. And Bert, do we have any changes to the agenda as has been presented?
Yes, Mr. Chair, members of the board, Bert Ross, planner for the city of Des Moines. I do have 2 changes to propose or to mention today. The first is that item number 7, which is two appeals at 4347 Merle Hay Road. We do have to discuss those today. We've gotten some objections from the Merle Hay Neighborhood Association, so we will be holding the full discussion on item number 7. And then the other change is that item number 9, which was an appeal at 2535 Hubble Avenue, that was withdrawn by the applicant. So that public hearing will not be held today. So if you're here for item 9, you're welcome to sign off. And again, that was the appeals for the U-Haul business at 2535 Hubble Avenue.
Okay. All right, so item 9 has been removed. That will not be considered. They would have to refile at a later date. Is that correct, Bert?
That is correct. If they would choose to move forward with the proposed signage, they would have to file an entirely new application, and then the city would mail new public notices out as part of that process.
Yeah. All right, so item 9 has been removed from the discussion portion of the hearing. Item 7, which was on consent, is being moved to the discussion portion of the hearing. So that would leave items 1 through 6 on the consent portion of the hearing, meaning that staff is recommending approval of the requested conditional use permits or the amendments to the conditions of those permits that are listed in items 1 through 6. So at this stage, staff is recommending approval of those items. If there's anybody that wishes to speak in opposition to us approving those items, what I'm going to do here first is read through all of them just briefly for address. And then if anybody wants to speak in opposition to those items, we're going to ask you to either raise your hand or to briefly be recognized, only so you can state which item you'd like us to consider on the regular portion of the hearing. And then we'll work that into the hearing and take testimony. So item 1 is a conditional use approval request at 6208 Douglas Avenue. Item 2 is a conditional use approval in the premises of 1900 Scott Street, Kemen Holdings. Item number 3 is an amendment to a conditional use approval for Fairway Stores at 2716 Beaver Avenue. Item 4 is a conditional use approval for the City of Des Moines, State of Iowa, near 2100 Sailor Road. Item 5 is a conditional use approval also for City of Des Moines and State of Iowa in the vicinity of 1501 Harriet Street. And item 6 is a conditional use approval request near 1301 Prospect Road, also City of Des Moines and State of Iowa. So is there anybody in the audience who would object to us granting approval for any of the items as listed on 1 through 6? If so, hit the raise hand function in Zoom or hit *9 on your phone, and we will look to recognize you. And I'll rely on city staff eyes and ears here. Do you see any hands up or requests?
I do not see any.
All right, going once, going twice. All right, seeing none, if there's any member of this board that wants us to remove one of these items and hear that, we can. If not, would there be a motion and a second by board members to approve items 1 through 6 as presented?
Mr. Chair, this is Justin Gross. I make a motion to approve 1 through 6.
And
this is Marlis. I will second that.
All right, so we've got a motion by Justin, a second by Marlis to approve items 1 through 6. We'll have Tyler help us take roll call, yay or nay on approving the consent agenda.
Lynn Carlson,
Yay, aye, yes.
Dave Gare,
Yes.
Justin Gross,
Yes.
Marlis Jones,
Yes.
Cindy Smith,
Yes.
and Mel Pins.
Yes.
That motion carries 6-0.
Okay, so if you were here for items 1 through 6, those items have been approved. And as I noted in the preamble, give us about a week and staff will get you a copy of that finalized decision and order, which has the approvals as well as the conditions you'll need to comply with. So congratulations to those folks with their projects. So you're here for items 1 through 6. We're done with those for the day. All right, since item 7 was removed from the consent portion of the hearing, that will be the first item we will take up for business. We'll have staff first give a brief explanation of the request for appeal.
Chair, members of the board, Jason Van Essen with the city's planning staff. Are you able to see my screen now, Mel?
Yes.
Okay, thank you, Bert. Item 7 is a request. It's a sign exception request for a type 2 zoning exception. The relief would be for sign area and then also exceeding sign area on a non-frontage wall. And I'll kind of talk about that a little bit further as I get into the presentation here. This is the subject property on the east side of Mulhay Road. You can see it's a fairly large site with several buildings, multiple tenants. The building and tenant space that we're discussing this afternoon is right here at the edge of this northwesternmost building. Faces both south towards the parking lot and also west towards Mulhay Road and the Mulhay Frontage Road. Some photographs of the property. This is from Mulhay Road, looking back towards the site, towards the east. Building sign area that would face Mulhay would be in this area. Working our way a little closer to the site, starting to see the south side of the building. This is the south face of the building towards the parking lot with the second location. This is the, excuse me, the non-frontage sign location. So the relief that is needed or as part of their application has to do with putting a sign on this area. The zoning ordinance does allow you to put up to 50% of your earned signage on a non-frontage wall. In this case, there would be exceeding that calculation for the non-frontage, and at combined total with both of these signs would exceed what would be allowed. Each sign in and of itself is less than what the actual maximum would be. Graphic from the applicant. I'll show you, flip through here. We can see the proposed signs of a pet supply store. They did provide some work write-up. We can come back to this if we need to. Want to go ahead and jump to the staff report. Applicant received this, provided it to the neighborhood association. The board members received it as well. Provides criteria, references the relevant code sections. Just quickly want to let's see. I think it's actually on the next page. Apologize. We have the review criteria, and then wanted to point out that each sign would measure 71, a little over 71 square feet in area. Their maximum sign area allowed to be 102.5 feet, and that half of that could be on that other side. So that's more in the 50 to 51 square foot, 52 square foot kind of range. So those are kind of the differences that we're talking about in sign area. In the staff rationale, as I alluded to when I started my presentation, we pointed to the size of the property, the setback, the sign area in relationship to the character or scale of the buildings, the scale of the development seemed appropriate to us. We didn't see that there'd be any significant adverse impact on the essential character of the area. And as a result, we are recommending approval, subject to the compliance with a sign permit as installed and issued to a locally licensed sign contractor. Response map. Didn't have any responses back from a property owner within the notice area that we recognized. We did get this one card, but the address wasn't for the notice area. Not sure what property they might represent. Then we also have a string of kind of email communication. I'll go ahead and focus and let you look. I'll zoom in a little bit and let you read. This first page really summarizes everything else in the rest of the email correspondence with the board of the Mulhay Neighborhood Association. They are opposed to the request and have requested it be pulled. So I'll give you a second there to read that. And with that, I'm happy to answer any questions you might have for staff.
Any questions for Jason?
I have a question. In your, this is Lynn Carlson. In the comments on our packet, it says that it's an auto dominant area. And that mall behind it, does that mall have retail, or is that all auto stuff behind that?
It has a mixture of uses. And what I meant by auto dominant is that it's comprised, you have a large roadway that carries a fair amount of traffic. You have a frontage road in front of that. You have large parking lots with the building set back versus the building.
Okay,
That was what my intent was with that.
I was thinking of all the car dealerships, so I,
Oh, yeah. Well, Merle Hay Road's known for that too. So.
okay, thank you.
Hey, Jason, Mr. Chair, this is Cindy Smith. I have a quick question.
Yes.
I believe there's a pole sign that is on the Merle Hay side of that building that identifies some of the tenants.
Did you see it show up in a picture that I showed or the aerial?
Well, no, I go to the gym there every day, so I think I remember seeing some kind of a sign. Maybe I'm crazy. I might have to look when I go tonight and let everybody know, but I believe there was a pole sign there because I believe that, and I'm not sure if there's pictures or not, but I believe that CrossFit Merle Hay has a presence on their building, as you can see. And there's also, yeah, you see that pole sign there?
Yeah.
It's also on there. So I was wondering if this pet store will also be part of the advertisement or a sign, if they would have an opportunity to have a sign, some kind of sign on that pole sign. And if that could make a difference for what they're requesting.
Sure. Let me look into that and see if we can get an answer for you after we have a little more discussion with the applicant's presentation and comment. Let me look into that a little further.
Sure. I don't mean to throw any wrenches in here. I'm just kind of curious, if they could have a presence on that sign also, would that help their intent for what they're trying to do? I understand trying to advertise your business, obviously, of course.
Mm-hmm.
Yeah, and this is Bert, planner for the city. They would be allowed to put a sign face on an existing freestanding pole sign. They couldn't make the pole sign any larger than it is or make any modifications to it. But if there is a directory sign or if there is space on this pole sign here where they could add a sign, they would be allowed to. I've just mentioned that any new freestanding sign would have to be a monument style sign with the masonry base.
Right. So just, this is Cindy Gimbert. So just to add to that, if they were allowed to, put their name, Pet Shop Supplies, right below where it says Merle Hay CrossFit or whatever the decision is made, would that then be part of their sign allowance, or is that different?
It's actually different. There is a
Okay.
tenant, they earn both wall-mounted signage and freestanding signage. And the
Perfect.
earnings
Thank
are
you.
separate. Yeah.
Thank you. Okay. That's what I was curious about, whether or not it was separate or it was all part of their allowance.
Thanks, Bert. This is Jason again. And I think it might be good to ask the applicant their intentions. That's not anything that's discussed in their application, so it didn't draw my attention.
Mm-hmm. Mm-hmm. Any other questions for Jason?
Yeah, I've got a quick one. This is Dave Gear. Jason, can you just put the picture back up of what signs they're proposing?
Sure.
I wasn't paying very close attention then. Thanks.
Oh, sorry, I went the wrong direction. Give me a second here.
Yep.
So it's the exact same sign on both sides.
So that's the west facade there,
That would be, yeah, west facade, and then here's the south.
south facade. So we have a before and a proposed after.
Yes, yeah.
All right. And
Okay.
Jason, there is no proposal to have a sign on the north facade, which would face the side lot of Charles Gavis Ford. Is that correct?
That's correct. Just the two signs.
And Jason, from a perspective of visibility of the business from the south, one might assume that, well, people are going to be on Merle Hay Road to get here and they'll see that sign that faces west. But if I'm correct, a lot of traffic would come from the south already on the site. Aren't there 2 or 3 entrances further south? And does this property also connect with some kind of connection road or a frontage to another strip mall or group shopping area further south? Is that correct?
Yeah, you can drive through this site all the way down to I wanted to call it Dolls, but Price Chopper and out on the street there. So yeah, it's yes, that's accurate.
Okay. All right. Okay. And anything else for Jason?
Yeah, one quick question. What again was staff's rationale for putting this on the consent agenda?
We felt that it was a reasonable request, that it didn't seem controversial given the scale and the size of what they're proposing as it relates to the building and how it sits on the property and the character of the property. And that's what led us to recommend approval. And we knew when we were preparing the agenda at that point that we were going to be supportive of it. And therefore, since it was an exception level of relief and we were supportive, we went ahead and put it on the consent agenda.
Perfect. Okay, great. Thank you.
Yeah. Anything else for Jason? Okay, well, hearing none, we'll go ahead and we'll let the appellant speak first. And so what we'll do, the appellant can have up to 10 minutes to present the reasoning for their appeal. And they need to start by giving their full name and their address. If you're here as a professional, as a contractor, architect, engineer, attorney, place of business. If you're here as a concerned resident or landowner, it can be the place where you live as appropriate. So who do we want to recognize here to kick us off?
Yeah, it looks like Miranda Cassins will be speaking.
All right, Miranda, we just need your complete name, address, and you've got up to 10 minutes to present your reasoning for your appeal.
Hi, Miranda Cassins from Chestnut Signs, 971 Northeast.
Nope, you faded out on us briefly.
Can you hear me now?
Yes.
Okay, Miranda Cassins with Chestnut Signs from 971 Northeast Broadway Avenue in Des Moines, Iowa. I'm here as a representative because we would be the company that would be installing these signs for the customer. Kind of the same case that the city was presenting. We're looking to have a presence not only along Merle Hay for motorists running along there, but also view from the parking lot so that people on the property can see where they're going and find the location. The customer requested the little bit larger signs in order to include their grooming and dog wash tags there. Basically, they said that's really important to them because that's part of their business that separates them from some other pet companies in the city. So they're offering some services that maybe some other pet supply companies don't offer, and they want people to be aware of that. And without that, it just doesn't identify them as well. So that's their main focus. They are planning on putting their name on that pole sign along Merle Hay Road there. But again, the space that's there is so small that they wouldn't have the room to give some of their specialties on that sign as well.
Mm-hmm. Okay. All right. Well, Miranda, you don't have to use all of your 10 minutes. So
yeah,
if
no,
you got
if
anything
anyone
else
has
to
any
add, great.
questions, if anyone has any questions, I'd be happy to answer them to the best of my ability. But other than that, I mean, there isn't a lot of craziness. I think the signs fit the space nicely. I don't think they're abnormally large in proportion with the other signage in this space. One thing that is kind of affecting this is with the recent code change, the allowed square footage at this property actually decreased. So in comparison to some of the other tenants that have been there quite a while, these signs are actually smaller than what's on the property already.
Okay. All right. Okay. Questions for Miranda from the board? Well, Miranda, I'm just going to throw you a quick one here with this photo here that Jason's left up. You've got your dimensions shown there with your measurements, and the way you've applied your drawing there in the photo, you've scaled that appropriately, relatively speaking. So with what we see in the picture, that's about the size and scope of what the sign would look like once it's applied. Is that correct?
Yes, that is correct. It is based obviously off photos and rough measurements, but it's scaled to
Sure.
the best of the ability. Yeah.
Yep. Okay. All right. All right. Anybody have anything else to ask Miranda from the board? Okay. All right. Well, hearing none, Miranda, we will check back with you in a few minutes here. So thank you very much.
Thank you.
Okay. For the next portion of this agenda item, is there anybody that wishes to speak in support of the applicant's request? They've got up to 5 minutes to present their reasoning for their support, and they need to hit hand raise icon in Zoom or *9 on their phone to be recognized. Anybody want to speak in support from the audience?
I don't see any.
Okay. All right, we'll do the same thing. Anybody want to speak in opposition to this item? Hit the raise hand icon in Zoom or *6 on your phone.
All right.
Okay.
We have Chris Morse with the Merle Hay Neighborhood Association.
All
Thank you.
right. Yeah, go ahead, Chris. Again, just complete name, your address, and you got 5 minutes.
Chris Morse, president of the Merle Hay Neighborhood Association, P.O. Box 31036, Des Moines, Iowa 50310. Mr. Chair and other members of the board, I thank you for your time and the ability to speak and stand in opposition of this appeal request. As I understand it from working with Bert over the last week or so discussing this issue, it is our opinion that based upon the qualifications for the exceptions to be met, that there needs to be all items, they need to check all those boxes. Specifically A, B, and C, the requested exception is reasonably necessary due to practical difficulties related to the subject property. B, the practical difficulties related to the subject property cannot be overcome by feasible alternative means other than an exception. And C, the requested exception will not have significant adverse impact on the essential character of the surrounding area. I would contest that these three boxes are not being checked off of this specific need, and I'll provide some examples. In regards to item C, going backwards up the list, if you will, this requested exception would have an adverse impact on the essential character of the surrounding area, as the Merle Hay Neighborhood Association, as well as the city of Des Moines, is working to revitalize this corridor. In reference to the city code changes, yes, there are a couple of businesses in the area that have been provided exceptions due to the changes and being grandfathered in. However, the code has been changed as we are looking to reduce the clutter in our city, including along the Merle Hay commercial corridor. In regards to item B, practical difficulties, I know the representative for the business shared that including the dog wash and grooming is an important attribute of this sign. However, I would argue that the sign, as it's being presented, those two specific items aren't really going to jump out to somebody that's along Merle Hay Road at this size. Also, as discussed earlier, I believe Cindy brought it up from the board, there is a pole sign that's going to be available for the tenant to lease if they so choose. And that would provide them another opportunity to reach out to the motorist in regards to their business and the things that the services that they're going to be able to provide. Lastly, again, going backwards down this list, if you will, in regards to item A, we do not believe that this has a practical difficulty, as this property is one of the closest properties along Merle Hay Road and the frontage road that is there. There's a pole sign that's available. And then there's other ways to get the word out. The Merle Hay Neighborhood Association would look forward to working with this business as well as any other business to get the word out about their services and their contribution to the community and our local economy. So we ask that the board vote no in regards to this exception request. And if there are any questions, I would be happy to answer them. Otherwise, I will relinquish the remainder of my time.
All right. Do we have any questions for Chris from the board?
Hey, Mr. Chair, this is Cindy Smith.
Yep.
Chris, if they were to take grooming and dog wash off each of the signs, would it appeal to you better in terms of the neighborhood? Or is it just overall too big? I'm trying to clarify exactly what the objection is.
The objection from I was just providing some examples and some evidence, since this is a fact-based board that's quasi-legal. Our overall objection would be to the size, light pollution, clutter, etc. We want all businesses going forward to adhere within the city requirements, and exceptions to not be provided unless there is a hardship or a practical difficulty. And we do not feel that this situation provides for those.
Okay.
Thank you.
Thank you for asking. Anybody else?
Yeah. Yeah, Chris, this is Mel Pins here. Hey, I tell you, I share your concern for reducing clutter on the Merle Hay corridor. I worked at Merle Hay Mall in high school and in college, well acquainted with the businesses there for more than 30 some years. But in this specific case, you had, and I appreciate Cindy's question, sounds like you're concerned about the size, but sometimes there are some practical difficulties. As this picture shows, a lot of people would probably approach this business from already being on the property, or might be inclined to visit the business if they knew what it was. But as you can see, if there's no sign face on the south side, would you find it reasonable that we would grant an exception to allow a sign on the south side? Is it the scale is your concern? Or again, if we're talking about reducing clutter, I understand that. I think a lot of the concerns, at least in the past, were the proliferation of pole signs, and not because there's one in the picture, but the sheer number of billboards on that corridor versus on building signage. So would you have any problem if we were inclined to grant allowing them a sign on that south facade, but maybe just smaller?
I would actually argue, because of my familiarity with this, that the frontage sign should be smaller. A lot of the traffic that you have back and forth between or along Merle Hay is commuter traffic.
Yeah.
And the ability to catch it out of your side eye, if you will, as you're going north or as you're going south, is not going to be as high as being able to see that sign on the south frontage. So I like I think we would be amenable to that. But again, my direction from the board and the discussion that we had is that we would like for this sign and future signs in our corridor to adhere to city code. So if that's an exception that needs to be made, I think that would be an appropriate move.
Okay. Yep. All right. Well, great. Any other questions for Chris from the board? All right. Thank you for your comments, Chris, and thank you for your service to your neighborhood association.
Thank you for all you do as well. I appreciate your time.
You bet. Okay. Is there anybody else who wishes to speak in opposition to the requested appeal? Going once, going twice. And just in the spirit of the discussion, but yet related to the case itself, is there anybody that has some general or neutral comments related to the item at hand? So you're neither for nor against, but anything related to this item. Same thing.
I don't, so I do see one. John Godron.
Okay. All right. Looks like we've got a hand up there. Go ahead, John. We just need your complete name and your address, please.
Yeah, John Godron here, 500 Southeast 18th Street. Just a quick comment here that these appear to be channel letters. I was sorry, I was off of on another, so I didn't hear all the discussion, but I just my personal observation that these appear to be channel letters, and you're charging the box square footage. There's a fair bit of blank paint wall space on this that I think you should take that into consideration. Thank you.
Well, John, I think you have a comment that someone might logically put out there. But I think I'm going to have staff go ahead and address that for how we look at those.
Sure.
Oh, go ahead, Bert.
I was just going to say, our signage ordinance requires us to take the measurements of the smallest rectangle that captures the entire sign. So we are obligated to measure the signage area based on the overall dimensions rather than just the area covered by text.
Yep. Yes. All right. Okay, but John, yes, we do thank you for that comment. That's maybe a good way to look at the issue of a neutral comment. So sometimes it's a good way to learn how the city ordinance works in that process. Anybody else wishes to make any comment on this item? All right, seeing none. Let's see, we'll see before we go back to the applicant briefly. Any other questions for city staff from the board? Okay. Is that a question from anybody? If not, we'll go ahead and go back to Miranda, since there was someone, especially that spoke in opposition. Miranda, do you have anything you want to add in closing? You have up to 3 minutes. You don't have to give any closing comments, but if you'd like to provide any final information, you get the final say here for testimony.
Thank you.
Go ahead. Yep.
I guess my only thoughts would be, he had mentioned removing the sign from the west elevation facing Merle Hay Road, as most people would be able to see the sign on the south, but that would remove any visibility of the business as you came south down Merle Hay Road. So I don't really think that would be a reasonable option. I do feel like the size of the property does represent the hardship here. It is a very, very big property. And yes, the building is fairly close to the road, but because of that frontage road, it is set back a little more. So I think looking at the size of the sign versus the building and the size of the lettering, I do think scale wise, it is appropriate for the signage. And as well as, I know the grooming and dog wash are smaller, but it does still set them apart a little. If someone comes to the property, they can say, oh, hey, this does have a different than any other pet supply store. So that, I think they do kind of answer the A with the size of the property causing the practical difficulties. I don't at this point see another feasible alternative. The pole sign, as I mentioned before, they can put their name on, but that space is even smaller than what the proposed building sign is. So the lettering would be even smaller. So I don't think that really affords them the ability to express what they need to express on the pole sign.
Sure.
And then as far as it having a significant adverse impact on the essential character of the area, I do understand, as mentioned before, trying to get rid of large billboards and things that are causing visual clutter. But I do also appreciate the fact that communities like to see tenants in spaces. So when you come into a strip mall, when you see a sign that says, hey, this property is revitalized, this property has people here, and seeing that and having that visual impact on people allows them to know that the businesses are booming, there's people coming in and out of there, and it doesn't leave it looking so blank and naked and kind of abandoned. So to me, I don't see the adverse effect of this sign. I think, again, as I mentioned before, that it fits the building nicely and it is character with what is going on in the neighborhood currently. So,
okay.
Does anyone have any other questions for me?
This is Lynn Carlson. I have one question. What would the feasibility be of making one sign smaller than the other to bring the signage down to more within the variance level rather than the exception, or just to make it a little bit smaller?
That's actually the opposite, Lynn. The variance, okay. Yeah. The exception level is the smaller request.
Okay. Is there any chance of making the letters or making one side just a little bit smaller just to reduce the size?
That would be up to the customer. Obviously, I do know the grooming and dog wash letters can't be very much smaller than they are and still be built as a channel letter. You get a letter too small and you can't light it. You can't get your hands in there to put the LEDs and that sort of thing. So there is a limited size of the height on the smaller letters.
Thank you.
Yep.
Okay. All right, so we've had our testimony and questions. So at this point of the hearing, we're going to close the public portion now, and we go to board deliberation. So board members, do you have any thoughts you'd like to share on some reasoning for either approval or denial? And subject to that, we can have a discussion, and then we'll see what motions we may have on the table. Anybody want to make a first go?
Hey, Mel?
Carlson.
Yeah. Let's go ahead and recognize Dave.
Okay. Recognize
Sorry,
Dave. That's okay. Go ahead.
Thanks, Mel. Hey, Mel, I thought some of your comments were pretty appropriate. I agree with you 100%. As far as the clutter that we're trying to reduce, I think is more in the pole, or at least as I see it, is more related to pole signs and just, I think just being overwhelmed going down Merle Hay or some of the other heavily corridor or traveled corridors in the community. So, I think the fact that staff saw this as put it on the consent agenda, I agree with their reasoning totally. And I think that the size of the sign it looks to me to be appropriate and not offensive, or, I don't see that as any kind of a offensive looking that's going to disfigure the building or create an adverse effect in that area. So I'm going to support this as far as staff recommendation, just so everybody knows.
Great. Any other thoughts?
Okay, now this is Lynn Carlson. To me, if I was driving by that, I would think it was a restaurant. So I think we do need to have a sign on here. And like I said, it is a big building. So the amount of signage doesn't really add to the clutter. And for those reasons and the ones that Dave and Mel mentioned, I'm in support of staff recommendation. So I will make a motion, if it's not too early, to go with staff recommendation.
Okay. Do we have any other thoughts or maybe a second?
Mr. Chair, this is Cindy. I'd like to just share a comment and go ahead and make a second to Lynn's motion, but I am excited to see this building finally get used. I think it's going to be a great purpose. It's a pretty innocuous use, and it's a pretty great use as many of us have pets that we love and care for and need supplies for. So I am going to go ahead and second the motion made by Lynn.
All right. So we've got a motion by Lynn, second by Cindy, grant the requested zoning exception for the signs as presented. So we'll go ahead and do a roll call vote. All those that would be in favor of the granting the requested exemption will say aye, opposed would be nay.
Dave Gare,
Aye.
Justin Gross,
Aye.
Marlis Jones,
Aye.
Cindy Smith,
Aye.
Lynn Carlson,
Aye.
and Mel Pins.
Aye.
Motion carries 6-0.
Okay. All right. All right, Miranda, just make sure you work closely with city staff on that sign permit. And as long as you're in compliance, then you'll get a copy of that decision in order by mid next week. Okay, so this will move us now to item number 8. This is a reconsideration of a conditional use permit request brought forward by the city's zoning enforcement officer. This item was continued from our September 23rd agenda. Relates to a property at 525 East Grand Avenue. So we'll turn it over to the city.
Chair, members of the board, this is Sue Ann Donovan, the neighborhood inspection and zoning administrator for the city of Des Moines. Bert, would you be willing to go through the slides for me as
definitely.
I talk? Okay, thank you, Bert. So this came before the board the last time. It was September 23rd, 2020. On a request to reconsider the conditional use permit for a bar tavern selling the liquor, wine, or beer. The board did continue the item because we were going to try and work out something with the tenant in line of how to run the business so it did not interfere with the residential neighbors in this area. I'm going to point out that East Village is a neighborhood with residents. And this bar, the operators of the bar were not being good neighbors. I am told that the tenants have moved out as of last night, but I do not have any confirmation of this. The thing I think we still should go forward with the hearing based on the fact that maybe once we hear the evidence, the board may want to consider whether or not a bar use in this building is conducive and protects the neighborhood, or going to a restaurant use would be more beneficial. Or if the board would like to do some different conditions on the conditional use permit going forward to more protect the neighborhood from this becoming another nuisance again. You will recall that this did come before you for reconsideration for a tenant that was previous to this tenant on a same sort of request because of noise and disturbances coming from the patio. So on the screen right now, we have an aerial of the area showing the location of the building. Next slide. Here's a picture of the building. And as you can see, it sits on the corner of East Grand and East 6th. And up above is an open air patio, which is where much of the noise seems to be emanating that creates a problem for the neighborhood. Next slide. So August 27th of 2020, I sent both the operators of the bar and the owners of the property a notice that we were going to discuss the conditional use approval due to the fact that the business had become a nuisance, which adversely affected the peaceful enjoyment of residents in the area, which is a violation of section 42-348-11 of the municipal code, specifically but not limited to disturbance of the peace, excessive littering, and excessive noise after 11 p.m. and traffic violations. One of the board's conditions on a conditional use says that they have to be in compliance with city ordinances, this being one of them. Can you forward to the zoning? There we go. So here's the zoning application that was filed in order to bring this forward back in the fall of last year. So in 2010 is when this first came before the board. They wanted to expand the existing tavern use to include the 85-foot by 45-foot area atop the existing building for an outdoor service area. Next page. So the conditions were the rooftop patio shall include an entrance from East 6th, have outdoor lighting, live outdoor music on the rooftop shall be limited to non-amplified performance. Any outdoor sound or music or any rooftop patio shall be limited to levels that will be considered background auditory in nature. And they had to comply with Article 4 of Chapter 42, which is the noise control ordinance, litter trash, and then number 9 is revocation if we find that the operation of the business constitutes a nuisance or exhibits patterns of violating the conditions set forth in the conditional use permit. Next slide. So we brought this back in 2019, as I said, because the then operator was having amplified music on the rooftop. The board explained to the owner that they couldn't do that anymore, but did not revoke the conditional use permit. So next slide. We brought it back in September. Applicable requirements for this conditional use permit are the proposed location, design, construction, and operation of the use adequately safeguards the health, safety, and general welfare of persons residing in the adjoining or surrounding residential area. The business is sufficiently separated from the adjoining residential by distance, landscaping, walls, or structures to prevent any noise, vibration, light generated by the business from having a significant detrimental impact on the adjoining residential uses. I think that is probably the biggest one, is that the operation of the business will not constitute a nuisance. Next slide. And again, we have the provisions on Article 42. Then we have a copy of the liquor license table that sort of shows which sections of the code that we're talking about. And staff recommendations. So I'm going to go in September. The next thing I want to talk about is on page 22, Bert, we got a letter from the attorney for the previous occupant or the occupant. We're still not clear if they've actually moved out. His response to the conditional use permit. So we're submitting that into evidence, although I do not believe they're here to speak to this issue. So that was his analysis back to us. If we want to go to, and I don't want to get into that too much because I don't think they're here to speak to it. We have cards. The first one, I'll let you take a second to read that one. The next one, again, is not in favor of the request. Or he is in favor of the request for the reconsideration.
Right.
Here's an email from a previous occupant, Brittany French. She actually moved out of the building.
Can you make that a little bigger? Thank you. Okay.
The next is a photo that Brittany took. She was concerned about the motorcycles and parked in a no parking zone, making it difficult for anyone to load and unload. The next picture then is a party occurring on top of the patio. Weather was nicer then. Again, the remainder of the email from Brittany. Again, like I said, Brittany has been forced to move out of the neighborhood. We have something from Alex Johnson that I'm sure she will present or he will present later. They produce a public records request. We have an incident report. I will note that there were shots fired in the business over the New Year's Eve, and again last Friday night there was a shot fired inside of the building. So you can kind of read if you want to read the incident report.
Yeah. So Sue, did I hear you say we've had 2 incidences of shots fired on different nights in the last few months?
Yes, there have been two incidents of shots fired.
Okay, so we have January 1st here, it looks like, on this one.
Yes, and then there was one Friday night that was reported and also was mentioned in news articles and has been confirmed that there was a shot fired within the building. No one was hurt, luckily. So,
but in this one, it appears it says victim. So was someone actually shot on January 1st?
Yes, I believe there was a victim on that one.
And this happened on or about the premises itself?
Yes.
Okay.
And then we have, if we go further, we've got a sort of the call sheet for the area. Oh, yeah, Bert, let them read.
Jeez. Okay. So, Ann, to the best of your knowledge, have there been any arrests in this assault?
I don't believe they've found anyone to arrest for the
Yeah.
January incident yet. I have not heard that.
Okay. All right.
Here's just your trip calls.
From your experience, Sue-Ann, for a quote average tavern, would you say in this relatively short time period, is that a normal amount? Is that more? Is it less?
I think it's a lot. I think that's a lot of calls.
Yeah.
This is Lynn Carlson. Do we know what DPQ is?
Disturbance of the peace, I believe.
Yeah,
Okay.
just for peace and quiet. Yeah, this is Judy.
I think they used to say that on 1 Adam 12. DPQ.
Not watch it show.
And then the next slide is continuation of the call logs.
Okay.
Here we have a report of intoxicated guests, miscellaneous screaming and motorcycles, coming from the roofed bar. So it's just more evidence of disturbance of the peace off that, out of that location.
Okay.
And as we go further on, it's sort of shown on a scatter map from a radius, 500 feet. Of course, not all of that, as you get further away from the building, can be attributed directly to, or even casually, probably to this.
Correct.
Location.
Yeah. Okay.
Page 45, it is more information about groups of people loitering, getting ready to fight. We did, if we look at page 46, reach out to the attorney of the then owner and tried to initiate a good neighbor agreement. We were never able to get that entered with them. At one point, they had told me that they wanted to increase the level of music on the upstairs patio so that they could get a type A sound permit, which would have been the 8 concert level permits a month at the higher, 85 to 100 dBA on that patio. So we never were able to reach an agreement.
Okay. And so you said the owner, and I just like some clarification on that. There's an owner of a property, and there's an owner of, a business enterprise that might be leasing the property. When you say good neighbor agreement with the owner, who are you referencing?
I'm sorry, you're right. Chair, I should have been more clear. We were at this point working with the leaseholder, the bar operator owner, not the property owner who we did not hear from them until the last couple days, but they were not involved in discussions on the good neighbor agreement.
Got it. All right. Thank you.
There, page 50, 51, we talk about they submitted a good neighbor agreement back, but again, that was the one that unfortunately we couldn't get signed because we couldn't agree on the level of sound. And then page 54 is sort of their good neighbor agreement coming back at us. It was never signed. Page 55 is a communication from the Historic East Village indicating that they discussed supporting the good neighbor agreement, but they weren't going to enter into conversations about it. So they may have something to say further about the nuisance that this bar created. Here's a complaint, December 20th of 2020, 150 people in the bar, none were wearing masks or standing 6 feet away, played loud music, and a fight between 20 people started. They called the police on that occasion. 57 is a picture of what was sort of people hanging out outside the bar on the corner. We had sent Gilbert a letter asking them to come in and talk to us about the sound permit. So this is a response to that information about the sound permit. Again, talking about amending the conditional use permit because they wanted to have more music. So yeah. I think, let me just click through here. I think that's basically all of my presentation. Some of these attachments, I believe, will be spoken to and referred to by other people who wish to speak on this item. I see January 15th, there was a notice to quit and vacate. It should be noted that the property owner did take up an eviction action for non-payment of rent, but did not address the nuisance or attempt to evict them for failure to comply with city codes. Here is your page 71 is the map, the response map.
So green means they support the city's position or revocation of the or reconsideration of the conditional use permit.
Correct.
Is that correct? Yeah.
Yep.
All right.
So I will leave it at that for now. I think even if the tenant that was causing the problems, it has vacated it, we have a site that may not be conducive to a bar operation in a residential district such as this.
Yeah.
If you decide to revoke the conditional use approval in its entirety, the building could still be used for a restaurant. And if they keep 50% food sales, they can continue to sell alcoholic liquor as part of food service. You could you could amend the use approval and say that there's absolutely to be no music of any kind on the patio, which may assist in reducing noise if it is rented as a bar, again, under the conditional use approval. Could include some of the provisions in a good neighbor agreement if you wanted to amend the conditional use approval, such things as no loitering signs, controlling the sidewalk, outside lighting where appropriate, and have those be conditions of a conditional use approval. I certainly do not want to have a repeat of what people lived through for the last several months with the bar that was in place, just moving another bar in and having similar problems. I don't believe that that would benefit the neighborhood.
Right.
So I think I will leave it at that. And are there any questions?
Questions for Sue Ann from the board? Sue, I've got a brief one here, and I referenced this earlier. So I believe, if I remember, this has been in front of us a number of times over the last decade plus. The owner of the property has been the same owner for the last decade, if I'm correct. Is that to your recollection?
Yes, that's correct.
Okay, so it looks like the original conditional use request was filed by, I think, what I call House of Bricks. So a tenant or a leasee that wants to operate a tavern, they were the ones that initially applied, correct?
The owners of the real estate,
yep,
actually operated House of Bricks, it's my understanding.
Okay, because that relates to a secondary question. So the current owner was the one then issued the original conditional use permit, but it runs with the property. So whether we change owners or change operators of the tavern, once that's issued, if the use comes back up for consideration for reconsideration or revocation, who are we doing that against? I mean, who has the standing here as the quote appellant to what you want to do? Would it be the owner of the property then?
Yes, it would come down. The bottom line is it would come down to the owner. Now, the first hearing that you had regarding the occupancy most currently that we're talking about,
yes,
the tenant came in. The tenant came in to defend on the first.
Got it.
Go round.
Okay.
They have told us they are not going to participate in this hearing, but it really is the property owner, the real estate owner, that is the beneficiary, if I can say it that way, of the conditional use approval.
Sure, because they ultimately, they either operate the location themselves and have income, or they are leasing it to a tenant and they have the income from that perspective. So the buck really stops then with the property owner here.
It does, yes.
Okay, great, thank you.
Yep.
Yeah. Any other questions for Sue Ann from the board? Okay, seeing none. So for the structure on this agenda item, the appellant, which would be then the current holder of the conditional use permit, the appellant has up to 10 minutes for them or their representative to address the board. So we'll turn it over to the appellant for the next 10 minutes.
And I'm giving their attorney, Will Reasoner, the ability to speak.
Good afternoon, Mr. Reasoner.
Good afternoon. Will Reasoner at the Dickinson Law Firm. Address is 699 Walnut Street, Suite 1600, Des Moines, Iowa, 50309.
Okay.
Thank you for your time today. I've got good news for the board, which is that Club 525 has officially confirmed to me that they have vacated and surrendered any possession of the premises. So Club 525 and Larry Mason Jr., the actual operator, they're out. They're no longer operating a business at this property. Clear that the bar operator was the one causing the issues, not the property owner here. It's clear from the police report information that Ms. Donovan showed. From what I could tell from that information, it looked like trip logs and everything started sometime in June of 2020, which is right when Club 525 came in the spring of 2020. So all these issues are obviously attributable to Club 525. The conditional use permit was originally granted in 2010, nearly 10 years without issue. So it's clear that the problem here was Club 525, not the property owners. Club 525, like I said, is now gone. We were clearing up title and possession issues just to ensure that Club 525 no longer has any sort of right of possession. We have commenced an eviction action that's pending in district court right now. But we, like I said, just during this hearing, we received email confirmation from Mr. Mason that they have completely surrendered possession. The Garden nightclub, which formerly operated in the southern area of the East Village, the Garden nightclub is planning on moving into the property. Now that this title issue is cleared up, I think that we're free to enter into an actual lease. Last Friday, January 22nd, 2020, there was an article in the Des Moines Register. It was written by Lee, L-E-E, Rood, R-O-O-D. In that article, it indicated that the garden had operated for nearly 36 years. Council member Joe Gatto and Council member Carl Voss are cited in the article as noting that there are few concerns with the garden moving into this location. They note that the garden's a longstanding business that has had few problems over the years. Tim, I believe his name is Ripma, R-Y-P-M-A. I noticed his name on several of the emails that Ms. Donovan cited to. Tim, from what I can tell, is an owner of property, residential properties, like apartment buildings near the location here. And he was also the owner of the building that the garden was formerly in. And in that article, he indicated that he's had no problems with the garden. And he indicated that if the garden would be a good neighbor in this new East Grand location, the more the merrier, he's quoted saying. All signs here point to the garden being a good neighbor and a welcome change to the area. Whether or not Club 525's activities may be constituted a nuisance is moot at this point because Club 525 is gone. The Wilsons, the property owners, they're considered of being good neighbors in the vibrant East Village community. A loss of the conditional use permit here will result in the building likely being vacant for a while and will prevent a Des Moines staple, the garden, from operating in the historic East Village. Ms. Donovan mentioned that, an alternative would be to operate a restaurant out of the building. Well, that's assuming that there's a proper infrastructure for a restaurant, that there's all the kitchen equipment in that restaurant. I think that's not a fair assumption to make here. Moreover, I think that it's completely appropriate for this board, well, I guess it wouldn't be this board, it'd be the city, to reach out to the garden about entering into a good neighbor agreement. Again, I don't represent the garden, but based on the garden's, track record for over 3 decades, I would certainly assume that they would be open to being a good neighbor. It's clear that Club 525 and Mr. Mason were not the good neighbors. The Wilsons, though, have rectified that, and it is in the East Village community's best interest to see that the garden has the opportunity to operate and be a good neighbor and a cultural contributor to the important neighborhood in the city. From a purely legal standpoint, I'd point out that the city has the burden of proof to demonstrate facts that are legally sufficient to remove a property right, which here's the conditional use permit. From a legal standpoint, I don't think that there's sufficient evidence to remove the conditional use permit. What we've got are anecdotal comments from the city itself. There's no hard evidence that I see that the city has met the high legal burden of establishing an actual nuisance. But, long story short, I think this board is most effective at finding good results for the community when it is problem solving and looking for solutions that can benefit everybody instead of a zero-sum decision. Aside from the legal issues, the problem that is cited by the city has worked itself out because Club 525 is no longer operating in the space. A respectable and longtime entity, the Garden, is going to be taking over. The Garden clearly has the support of major property owner in the area, as well as 2 city council members. The right result has occurred in this case organically. The problem is solved. Club 525, which was the source of the issue, is gone. There's no reason to devastate the property owner and prevent good use of property by a respectable entity. An entity, the Garden, which has contributed to the vibrant culture of the East Village for decades and will do so from this property going forward as long as this board does not prevent it from happening. Board, unless there's specific questions for me, Ms. Nancy Wilson, who is the property owner, would like to use the rest of the 10 minutes.
Well, she'll have to make it quick then.
I'm going to go ahead and mute myself.
And
All
Nancy,
right, Nancy, we need your complete name and address, please, and you can use the remainder of Mr. Reasoner's time.
Hi, I'm Nancy Wilson, and one moment. I live at 901 Walker Street. I'm co-owner of 525 East Grand and was the owner of the business between 2005 and 2017. As my lawyer said, Club 525 has already moved out. By still requesting that the CUP be taken away, you're asking us to be held responsible for the actions after the fact. But as landlords, we don't have a lot of legal remedies to resolve that situation. We can't kick them out because they have complaints from neighbors. No evidence was ever presented to us that they violated the sound ordinance, and our hands have been tied. So we tried to work with you and we tried to work with our tenants, and we hope for the best. I do believe that the process should be easier and more transparent. We've rarely been informed about meetings or decisions except for the official ones, and we've never been informed directly about complaints or problems. If our tenants wouldn't have told us, we never would have known. I'd love to be informed as soon as the city is aware of any issues so that we can actively help to resolve a problem instead of just defend against it at a hearing. We've asked for and been denied access to the evidence that is going to be presented by the city at the hearings, and basically just told it's going to be presented at the meeting. So I had no idea that there were shots fired in my building. I had absolutely no idea until she just said it. We've never been notified. I had no idea. I don't know, as far as this whole process goes, I don't know what the criteria is for the nuisance or whatever. I think Will kind of talk to that. Trying to go through my information here. I guess that's all that I have. We do have a new tenant. Hopefully if we don't lose the CUP, we can get everything signed and get them in there. So I guess we're just requesting that this be dropped and allow our new tenant to come in and start fresh, just as any other new tenant that would be coming into the East Village would be allowed to do. And I thank you for your time today.
Okay, all right. So what I'm going to do here, board members, do we have any questions for either Nancy or Will?
This is Lynn Carlson. I have one for Nancy.
Yes.
As a property owner, your attitude of not being notified of anything is kind of I think, a head in the sand approach. I mean, the other person was able to get information out with filing for police reports of what's been going on in that area. And as a landlord, I think you could have done that. And I knew about shots fired, and I don't even go to bars because I read the newspaper. And Sue Ann said it was very well open. And I'm just wondering if we were to extend this to you, because the permit does belong to you, what actions do you intend to take to make sure that you be more active and aware of what's going on in your property?
I guess I would be open to suggestions, because other than calling down and asking for those reports every week, I'm not sure what I can do. And I guess I was, in the past, we had been told that Sue Ann would communicate with us, and we would be a part of this, and we would help in any way that we possibly can. But I other than, checking every week or, requesting those reports, I'm not sure how that we can do that. But if you have suggestions, I'm open to suggestions, and we would do anything that you would, have in mind.
Okay. Thank you.
All right. Other questions for Nancy or Will? Okay, I'm going to throw one out. Will said that this has been solved organically. And Nancy said she wasn't aware of even what was going on down there. So I am wondering who's in charge here. Will or Nancy, did you issue an eviction notice to Mr. Mason, or did he just organically decide to leave? What is the reason for his departure?
Yeah, can you, am I still recognized? Can you hear me?
Yes. This is, yeah.
So, they failed to pay rent. So this is going to get into some technicalities under the Iowa code on how you can evict people, but there's a failure to pay rent. And so we issued this notice. It's on your screen now for failure to pay rent that wasn't cured. And then we entered into negotiations with Matthew Gilbert. You also saw his name quite often. He represents Mr. Mason, but he does not represent Club 525 LLC. So that's just a legal distinction that I guess we don't really need to get into. We've commenced the eviction action based on failure to pay rent. So it's a breach of contract basis with the landlord. And when I say organically, I mean that a problem tenant who is obviously causing problems to the neighborhood, was also causing problems to the landlord here, not paying any rent. And so organically, it worked itself out in terms of we don't need city action depriving a property owner of use of property in order to get someone else in here. And we're getting in the Garden nightclub, hopefully, as long as this permit is not taken away.
Okay, so that's very helpful. And in the letter you have, it says January 15th of 2020. So just more than, is that correct? Or are we not used to 2021 yet?
Yeah, well, thank you. If you look in the middle, where I itemize the amount that's due, it says January 2021. So maybe.
Okay, well, kind of what I'm getting at here then. So basically, by the time the city had issued its draft agenda, it looks like only then did you press the gas to get them out of there. Did you issue any previous notices? Were they not delinquent in their rent? I mean, when did you really start putting the pressure on to say, hey, you guys aren't performing within the terms of our lease?
In December.
Yeah.
Okay.
Non-payment.
So in September, when we put everybody on the warning track and said, do not come back to the principal's office, we do not want to see you here, all of your actions against the tenant have taken place since you were in front of Board of Adjustment in September. Is that correct?
Yes.
Okay. All right. Now I want to turn to the future here, because this seems to be where everybody wants to head. If we want to put the past behind us and we want to look to the future, how do any of us know that it is likely that this other tenant, the Garden, would plan to be in there? Do you have any pre-lease intent to enter into any agreements? Do you have anything in writing from them? This is a hearing. We don't use things from the Des Moines Register. So do you have anything documented that you're negotiating a lease with them?
We actually do. We have a lease that is signed by them, but not by us, because technically we were unable to release the property until the eviction went through. So
Okay.
it is signed by them.
Yeah.
But I don't believe that we'll be able to go through with that if we lose the CUP.
Okay. All right. Yeah, I'm just trying to see how strong a bridge would be here of likely tenants, because again, in this case, the conditional use permit, Nancy, if you were of the Wilsons in 2010, you were the one who received the initial conditional use permit. Is that correct?
That's correct. And we didn't have any trouble the whole time we were there.
Right. Okay.
12, since 2010.
Now, did you have a different operator there in 2019, but before this Club 525?
Yes, we had a tenant that failed to abide by the terms of the lease, and he had music on the rooftop. But
right, because I think that tenant was in front of us as well.
Yeah.
So in the last 2 years, you've had 2 tenants who have failed to comply with lease arrangements, operation in accordance with the conditional use permit, excessive noise. That's not the best track record for when you lease this out to others, don't you think?
Well, one of the things that it's really hard. When we originally talked to Larry, they said that they were going to be a nice, relaxed jazz and blues club. And that's what they pitched to us. And that's what we thought when we originally signed the lease. That didn't happen. And it's truly unfortunate. And I wish we wouldn't have rented to them, but I don't know that there's a way to say this person is going to be bad for your business.
Right.
He's a respected person in the community. He said all the right things.
Yeah.
We trusted him and we believed in what he was going to do, and he failed.
Yeah. But you did eventually, you took action against him for failure to comply with, maybe not that he wasn't complying with the conditional use permit, but he at least failed to comply with the terms of your lease, correct?
Correct.
Okay. All right. Okay, any other questions for Mr. Reasoner or Ms. Wilson? Okay, all right. We will check back with you in a few minutes here. So now for this next part of the hearing, this would be a little different than when the applicant would lead when it is not the zoning enforcement officer. So this next part of the hearing is anyone that wishes to speak in support of the city's position to have the Board of Adjustment reconsider this conditional use permit, including the possibility of revocation. So if anybody wants to support reconsideration of that permit and or revocation, now is their time to speak. So who wants to speak in support of the city's position on this item? Hit the raise hand function in Zoom or the *9 on your phone, and we'll have staff work to recognize you.
Great. Alex Johnson should have the floor now.
Thank you. Can you hear me?
Yes, sir.
Yes.
Thanks for your time and attention to this. My name is Alex Johnson. I'm an attorney with the Brown Winnick Law Firm at 666 Grand Avenue, Suite 2000. And I'm here to speak on behalf of RE Properties, LLC. If you recall that map that Ms. Donovan showed, several of those properties with the green are owned by RE Properties, LLC. So they're within, I guess, what you would call the zone of affected neighbors. RE Properties and its tenants have a vested interest in growing and maintaining the East Village atmosphere, the reputation, the environment, and maintaining good neighbor agreements that follow all the laws and regulations set forth by the city and are conducive to a good environment. They're also committed to supporting their neighbors. My comments were mainly going to be directed toward Club 525. And so, as you can imagine, a lot of that doesn't pertain much anymore. So I'll shift gears a little bit. I have read the entire agenda, and I wholeheartedly agree with the position taken by the city, which I think means to revoke the conditional use permit. And in light of the updates mentioned, I want to focus on the noise issue. And Ms. Donovan spoke a little bit about the fact that she didn't know if the city would know if this location would be appropriate for a nightclub. And it sounds like, based on the comments we just heard, there have been at least two situations in the past few years where two different businesses have been before the city for noise-related violations related to the rooftop. The rooftop noise has been an issue throughout the entirety of Club 525's tenancy, and it sounds like it's gone back even further. Our position would be that the city needs to take a good, hard look at any type of music or amplified sound on that rooftop, no matter who the tenant would be. We don't want problems like this to, as Mr. Reasoner said, work themselves out. That shouldn't be what neighbors have to resort to. I think the city needs to step in and legislate to make sure these problems never happen to begin with. I think I'm beating a dead horse by telling you that Club 525 is not a good neighbor, has not lived up to the standards of the East Village, has not followed the city's rules, not just with respect to noise, but they've been a nuisance in other respects as well. There's been garbage, traffic. You've seen all the police call reports and the shots fired reports. I understand Detective Minahan has not been able to finish his investigation with respect to the January 1 incident. And my guess is that the one that just happened this last weekend hasn't even been written up into a preliminary report. So we think those things should definitely be considered by the city, no matter who's in this space. We strongly request the city to not only deny the 525 permit, but to further look into the conditions and what needs to happen to make sure whoever is in this space, I understand the ownership has been the same, but whoever the tenant is that goes into that space, that they are forced to follow the rules, the city's ordinances with respect to noise, garbage, being a good neighbor, time of business, etc. And so for all these reasons and those that the city cited in its own agenda, we believe that the permit must be denied or revoked to maintain lawful compliance in the East Village neighborhood and to prevent further nuisance and damage in the area. Thank you.
All right, thank you, sir. All right, is there anybody else who wishes to speak in support of the city's position? Any other hands up?
I am not seeing any yet.
All right, or hit *9 on your phone if you're participating by phone. Going once, going twice. Okay. So for the next part, do we have anybody who wishes to speak in support of the appellant, which is in essence the holder of the conditional use permit? So for these purposes today, the property owner. Is there anybody that wishes to speak in support to allow retention of the conditional use permit for this location? And again, hit the raise hand function in Zoom or *9 on your phone to be recognized. And same on that. Anybody?
I do not see any hands.
Okay. And then is there anybody kind of in neutrality, or is there anybody that wants to make any general observations about the specific things related to this case at this location? Same sign, raise hand, or *9 on your phone. Okay, seeing none. Board members, do we have any general questions for the city staff?
Chairman, this is Justin Gross. I have a question for Sue Ann Donovan.
Go ahead.
Sue Ann, the patio on this property is relatively new addition, is that right?
I think it came in 2010.
But it was after the original CUP was approved?
I think it was because it was an expansion of the conditional use approval to include the patio, and that was the last one that covered the whole building. Yes.
Thank you, Sue Ann.
Any other questions for Sue Ann?
I have a question for Sue Ann. The good neighbor agreement, does that involve just the person who's operating the business, or is there a way to include the property owner into it, so they are involved with the neighbor meetings and aware of what's going on without having to call the police every week?
I think that you could include good neighbor agreements. I'll sort of back up a little bit. Were created through the police department to deal with problem properties where they had loitering and things like that, to get lights put up and no loitering signs and that type of thing. It's sort of the concept morphed into this case in that fashion. So we don't normally in neighborhood services do good neighbor agreements. We were trying to work it out in this case at the request of the board to see if we couldn't resolve issues before it came back to the board. I do believe that the property owner, it is incumbent upon the property owner to understand what's going on in their property and to take responsibility for it. So basically what that says is that when we put terms and conditions into the conditional use approval that have to be followed, those run to the landowner to make sure that whoever's occupying are abiding by those terms and conditions of the conditional use approval.
I agree with that, but I just know if it was included or not, because I don't think I've ever read one totally. But
no, if the board wishes for us to enter a good neighbor agreement with the property owner, we can certainly do that. It will be very close to what the board may put in its conditional use approvals anyway. So it's up to the board which way you want to go with it.
Thank you very much.
Hey, Sue Ann.
Go ahead, Dave.
Hey, thanks, Mel. Hey, Sue Ann, what's the city's recourse on a good neighbor agreement if the residents around there still feel like it's unacceptable based on the noise level, whatever, disturbance? What's the recourse there?
I suppose we'd have to take it to court and try and get a civil penalty or something like that. I would much rather have whatever the board wants them to abide by. If they decide to continue the conditional use approval or extend it and not revoke it, is to put whatever you want them to do, put in the board's decision in order, rather than have a separate document that we have to figure out how to enforce in a different method than bringing it back here.
Okay, and I'm tracking a little bit with what some of Lynn's comments and what some of your comments were, but to me, a good neighbor agreement just seems like a handshake, and there's nothing behind it. I think we'd be better off, depending on which direction we take this, of putting some conditions together that are going to hold the tenant and the owner accountable, because I'm shocked that the owner doesn't know what's going on. It almost sounds like they're an absentee owner, like they've got a residence in Des Moines, but they spend part of the time out of town too. That's amazing. So anyway, you've answered my questions. I'm looking forward to the board discussion. Thanks.
Mhm. All right, other questions for city staff?
Chair,
Sue,
do
yeah,
I get
go ahead.
rebuttal?
Well, yeah, you can, but I got a question for you first.
Sure.
So, this was just brought up and Dave referenced it. Here and there, I hear about these good neighbor agreements. I've served on this board for a number of years. I didn't hear much about them in past years, but just colloquially, it always seems to me it's the police department that historically has put together, quote, good neighbor agreements, sometimes with landowners, maybe an apartment complex owner to like help them keep, drug sales from happening in a parking lot, or good neighbor agreement with a car wash so that there's no loitering on the property. But by and large, with the review of the zoning board of adjustment and the duties we're charged with, within the city ordinance is not a conditional use permit by its design a legal good neighbor agreement that says you'll operate so that you're not a detriment, you're not going to disturb the sound, the quality, the character with noise or light, etc. Would you agree with that, Sue Ann?
I would absolutely agree with that. The history of a good neighbor agreement is you have, for instance, a convenience store on 6th Avenue that has a lot of people coming and going and prostitution, and instead of going in and arresting a lot of people, what they do is they go to the property owner and say, here's what we need you to do to keep the criminal activity down at your property. It's a good neighbor agreement. You need to put up lights, put up no loitering. Make sure that you have an off-duty police officer or a guard to make sure that people move along. There are agreements with owners to limit the amount of illegal activity, drug trafficking, and that sort of thing. The 525 and some other people asked neighborhood services to draft a good neighbor agreement in order to try and get some of this done. So that's what we tried to do, but it doesn't hold any force in effect.
Yeah.
And the best enforcement tool is your conditions and your conditional use approval.
Right. Okay. All right. Thanks for clarifying that. Any final questions for Sue Ann?
Okay, I have one for Judy. This is Lynn.
Go ahead.
Okay, as you mentioned, our conditional use permit does have a lot of the conditions in the good neighbor agreement, and the good neighbor agreement is, not really highly enforceable, but is there a way that we could put into the conditional use permit something about the landlord has to meet with the neighborhood association on a quarterly basis or something like that into just her CUP, since she doesn't seem to know how to know what's going on?
Well, that's a novel approach. I guess I have not seen it in other conditional use permits, but I would not be entirely adverse to that. I know that in code matters, there are oftentimes requirements for going out and meeting with neighborhoods. This is kind of analogous to that, just something that enforces that they are actually getting together to discuss things which we would normally expect would happen naturally, but I don't see it as being an impossibility to put in there. You'll need to craft kind of what sort of documentation of that you would expect, but I think that's a possibility.
Thank you.
All right. Sue Ann, I'm sorry, I missed something in my notes here I wanted to ask you. I believe it was stated by the appellant, the property owner or their legal representative that this site hasn't been in front of the Board of Adjustment with any problems until Club 525 here in September. I may need some help in recollecting here, Sue Ann, but I don't believe that's true. Did we not have this in front of us maybe within the last 2 years where there was an operator who was having amplified music on the rooftop, publishing it on Facebook, people singing in microphones with speakers, and it was in front of us. And we did say you have to understand this conditional use permit and make sure your tenant, your bar operators understand it. Did we have this in front of us? Am I correct?
Yes, you are. We did have this in front of you, I believe in 2019. And the Wilsons were present.
And that's
were
what you
part
have
of
on the screen now?
Yeah, I think Bert put it up for us. Thank you,
Okay.
Bert. And we're informed at that time that the tenants needed to be aware of the conditions of the board of the use. And they were present. They knew what was going on.
So was it the board's intent at that time? Did we say you are done with amplified music on the rooftop? Did we like reaffirm that condition, or did we deny the request for that expanded amplified stuff on the roof?
This was a case where we brought it again for violation of the use permit for having amplified music on the porch or on the rooftop patio. They also applied for an amendment to the conditional use approval to increase sound on the patio. Board decided not to revoke the conditional use permit with the understanding that they didn't have amplified music on the rooftop. They withdrew their request to amend the conditional use approval regarding sound.
Okay. All right. So within a little over 2 years, we've had 2 different tenants, 2 different times with sound and noise problems and violating the conditional use permit. Correct?
Correct.
All right. Okay. All right. Just for clarity on this, and then we will get back to the appellant here. Any other questions for Sue Ann from the board? And I'm going to make this the final one for questions because Sue Ann gets a rebuttal. So I'm going to, in all fairness here, she's got to make that less than 3 minutes. So whatever Sue Ann says, that's going to be the last we talk to the city then. All right, board members, you okay with that? All right, I'm going to turn it over to Sue Ann. You can have your rebuttal for your closing, and then we'll go back to the appellant.
So some things I'd like to point out that the Wilsons were invited to a meeting with Des Moines Police Department, City Council, myself, and other staff people, I believe in August of last year, and were told what the concerns were of the police department and the noise control concerns. So, and then they were invited to participate in the last hearing. They have been involved in what we're doing. They have not reached out. They didn't reach out to us after the last board meeting to talk about any agreements or anything. So I figured they had left it up to their tenants. But you know, it's kind of interesting that they know what's going on, and the action they take to resolve it organically is to do an eviction for non-payment of rent. But I don't see any action or notices to the tenant of a lease agreement for failure to comply with the Board of Adjustment conditional uses. You know, they really should take the lead on managing their property. If I know about a gunshot several hours after it happens, you would think that they would be somehow in the loop or figure out how to manage that that space when they know that there's trouble going on in that space. There have been restaurant uses in that building before this tenant moved in. I believe it was La Hacienda. I know La Hacienda was in there, and I know they have a kitchen. I have no problem necessarily with the garden going in there. I do know that the garden operated probably without any problems. They were down in a warehouse industrial district in a building that was completely brick, and no sound would probably be able to escape from it. I do know that their music of choice when they were in that building was techno or techno rock, which is quite loud. So if they're going to move into this building, they have to understand that that music is going to escape from this building. It isn't soundproofed. It doesn't have any characteristics of the building that would keep sound inside of it. In fact, it's sort of the patio and the window system will allow sound to escape. So I would hope that if the conditional use permit is not revoked and remains in force and effect, that they are aware, and I would assume it's the Wilsons that would need to be negotiating that with them. How do they stay in compliance with the city ordinances? And I think that's incumbent upon the property owner to make sure their tenants are managing the business so it's not a nuisance.
Mhm.
So I will leave it at that.
Okay. All right. Okay. Well, that closes that part of this item. So what is left here? The appellant, they have up to 3 minutes for their rebuttal. They, in essence, get the final word on any testimony here to the board. So, Mr. Reasoner, Nancy, you can share this time however you want, but you've got up to 3 minutes.
Thank you. Am I able to be heard?
Yes, sir. Go ahead.
Okay. Again, Will Reasoner here. Just want to touch briefly on something Ms. Donovan just said. The landlord-tenant law in Iowa, you're not allowed to a property owner can't just evict a tenant for whatever reason. The basis for eviction is grounded in contract law. So there has to be provision in the contract which is being violated. I don't think that it's appropriate at all for this board to, some way discredit the eviction here because it's based on non-payment of rent. Non-payment of rent is the most common way to evict somebody. I've personally been involved in, many landlord-tenant issues, both residential and commercial, where the real issue is not based on non-payment of rent, it's because of something else, but you use non-payment of rent as the way to get it out because it's the cleanest. Shouldn't imply any sort of wrongdoing here. I think that it is appropriate for this board to put some, restrictions isn't the right word, but some conditions and, to specifically state what they'd like to see from the property owner here. But from all accounts, the garden's going to be a good neighbor. They're going to be respectful. And I can't remember which board member brought it up, but I think the idea of some way of the property owner meeting with or hearing from the neighborhood association as a routine, I think that that's a good idea. And that's what we should be looking for here is ways to solve the problem instead of saying you can't operate here. I think there's creative ways to go about this that benefit everybody. And without violating any sort of property rights.
Mm-hmm.
Thank you.
All right. Thank you, Mr. Reasoner. Okay. Well, that will close out testimony on this agenda item. So we'll now close the public portion and we will go to board deliberation. So colleagues, any initial thoughts, concerns, options, approaches?
Hey, Mel.
Yep.
This is Dave. I've got a couple at least get us started.
Sure.
Based on some of the comments that have come up through this, I think we finally got the owner's attention. And it's kind of interesting that it gets down to limiting the use of the property or restricting some things, as that's what it took. But seeing how that's where we're at, and I'm all about solutions, I think hopefully we can work toward some kind of a win-win situation here. But there's developers downtown that are spending millions of dollars building multifamily apartments and opening restaurants and businesses. And I think the Wilsons ought to get on board with those people and make them aware of what they're wanting to do. And they want to be a good citizen of the East Village as well, because I think they've been negligent based on just the evidence that's been presented today. My initial thought as far as the sound goes, I'm inclined to revoke any sound on the patio up above, 0. And if there's a new tenant, let them come in and present why we should permit that. And I would suggest that before any of that occurs, that they meet with the people across the street. They meet with some of the other developers in the area that were named in the paper. And let's try and get these people to work through this together, because what we could do, I think you could just revoke the current conditional use permit, and the Wilsons are gonna have to try and find another tenant or their building sits empty. And that might be a good lesson. I don't know. I'd hate to see that because this is such a vibrant area. But, you know, I don't like punishing my kids either, but I do. Hopefully that's going to change some behavior and it's going to get some people's attention. So we've spent way too much time talking about this over the last 12 months. And Sue Ann recognized another time that it came up 5 years ago. So I'd be inclined to try and work to some sort of an agreement that would require some pretty hands-on involvement by the owner, as well as their prospective tenant, with the property owners and the residents around the area. And I'm pretty staunch on having zero sound outside for the foreseeable future, because I think we eliminate one of the variables that we continue to talk about, and we continue to measure, and we continue to debate. And maybe that's just not, maybe that doesn't belong at this property. So I'd be interested in what everybody else's comments are and go from there.
That's a good segue, Dave. What do others think?
This is Lynn Carlson. I totally agree with Dave's comment about no sound on the patio at all. I would also maybe be interested if other people thought about having no liquor served on the patio. Somebody might want just a quiet place to talk. I just think sometimes when you get the liquor, voices get raised, and they, from comments I've read, the voices carry across the street. I know they do where I live. So make the rooftop just, you know, no liquor, no sound. I would like to see incorporated into the conditional use permit that the property owner, the Wilsons, need to meet with the neighborhood association at least 4 times a year, so once a quarter, with reports from the association on the results of the meeting being sent to Sue Ann or somebody else designated that they just check off, you know, on the first very course, like January 1st, March, whatever, go on the months, that they've met with them and the results. And I think that if they're aware of that, she wants the property. She has run it in the past, but we need to ensure that she is staying involved. I mean, I am a person who is COVID bound. I stay home because I am high risk, and I knew about the shots. So I'm not like in the bar scene or anything else. And I found it totally astounding that she was not aware of something that severe in her own property. So I'd like to see that written into the conditional use permit rather than a good neighbor agreement, because if she violates that, I just want that revoked. You know, it's kind of, this is the last straw. My thoughts.
Other members?
Chairman, this is Justin Gross.
Go ahead.
Thank you. My fellow board members, I think there's a little disconnect here from the owner here. I mean, they were put on notice back in 2019 that the property needs to be managed differently when it is not owner occupied. And they failed to heed this warning. And I think if we don't revoke today, we would have to really consider amending the conditional use. As Dave pointed out, I agree, no sound on the patio. I think the idea of the quarterly, meeting quarterly with the neighborhood organization or association would be important. I think also, I think it's beholden on the the owner to get those call logs weekly to be more informed of what's going on in that property. I know one of the reports mentioned that there was no cameras in the place. I thought that was shocking. And I don't know if we can, this may be a question for legal, but, I don't know if we can do some sort of one more strike and you're out sort of revocation. If this comes again to the board, that it's almost, a certain revocation of the conditional use. So those are my thoughts. Thank you.
Thank you, Justin. Anybody else want to add anything?
This is Marlis. I agree with no sound from the patio upstairs at all or anywhere outside. I do think, though, that we are giving this person a lot of chances, and I'm getting a little bit tired of that.
Mm-hmm. Yep. All right. I think it might behoove us to hear from all of us here today. Cindy, do you have anything you'd like to add? I don't want to put you on the spot.
Well, I don't want to say what's already been said, but I did notice when Sue Ann was speaking, her comment was that the owner should take the lead on managing their property. And I thought that was very succinct and pretty much said it all. For these past, 5 years, the city's been managing this property and we need to get it turned around. So we need to take whatever steps we can take to get it turned around.
Yeah, very well put. From my perspective, I have served on this board for some time, as some others have, and whether somebody has served a short time or a long time, everybody has great observations on all our cases. But I remember when this started, the Wilsons have had an ownership interest in this property for more than 15 years. When we issued that rooftop patio, if you want to call it that, in 2010, the conditions were clear. There weren't supposed to be amplified sound up there, background levels of conversation. We had plenty of conditions. Who was all of that issued to from the original conditional use permit? It was issued to the Wilsons. So they knew the basic tenet, the constitutional approach to how a conditional use permit worked and what was expected of that. So in 2019, they had a different tenant in there. I believe the Wilsons were present, at least one of them at that time, and everybody seemed to be ignorant of the conditions in the conditional use permit. And I reiterate it, the owner has an obligation to understand that, and if they're going to be leasing that, to explain it to the tenant. The tenant said, we had no idea there was a conditional use permit, or we didn't know what the limitations were. I chastise the owners at that. So that's strike number one. So then strike number two, we get here in September. Mr. Reasoner was here. I don't know if he was legally representing the owner of the property or if he was in some way trying to be a broker between the tenant and the owner. But that's when we drew the line in the sand. There was a second strike. I specifically remember saying, I do not want you back here. The city wants to revoke your tavern conditional use permit. We don't want to do that to you, but it's like giving the keys to the car to the kid on prom night. Don't crash the car. I said, if you're back here again, it's going to be bad news. So even with that warning, with the owner present there or aware of what was going on there, what do we have now? The second closest worst thing that we could have, 2 shootings within weeks apart where someone was injured. Thank God they weren't killed on or about the direct premise. This wasn't 2 people that had a disagreement and left and had a shooting later. It was there. So that's our third strike. I'm done with this place. The owners know better. The owners had the original conditional use permit. The conditions have been out. There was nothing brought forward by the owner or their attorney that they have the conditions of the conditional use permit written into their lease agreements one way or the other. Sorry, you can't answer that now. Everybody looks so forward to the garden. Well, guess what? Nobody was here today from the garden to speak on behalf of the owner of the conditional use permit to hope that we didn't revoke that. I don't know if they're just sitting in the background waiting, but I'm tired of it. And, there was a little phrase, George Bush messed it up. I'm hopefully not going to fool me once, shame on you. Fool me twice, shame on me. I'm not going to have that again. I am not going to support continuing with this conditional use permit. So if my colleagues choose to do so, they can put a motion forward to do that with appropriate conditions they'd like to see. But that's not something I'm going to support. So for further discussion here, staff is recommending revocation. So I'm going to go ahead and make a motion for revocation of the conditional use permit. That'll have to have a second, and
I
then
will
we'll have to
second
have a
that.
vote. All right,
I
who
will
is the
second that.
All
This
right,
is
so I got a
Marla.
motion from Mel, second from Marlis for revocation of the conditional use permit for this address. All those in favor of revoking the permit, we'll take roll call. Aye for revocation. Is Tyler warming up for us? I can't hear him. Oh, there he is.
Sorry. Justin Gross,
Aye.
Marlis Jones,
Aye.
Cindy Smith,
Aye.
Lynn Carlson,
Aye.
Dave Gare,
Aye.
and Mel Pins.
Aye.
Motion carries 6-0.
Okay, well, we've heard that issue. The owners can follow up with city staff to get a copy of this decision in order. So we have a number of other items that we need to give attention to on our agenda today. Item number 9 was removed. I believe that will bring us to item number 10, which is a zoning variance request at 2324 Euclid Avenue.
Yes, Mr. Chair, members of the board, Bert Ross, planner for the city of Des Moines. Item number 10 is a request for 2 zoning variances that would allow installation of 4 wall-mounted signs on the north wall of the existing building at 2350 Euclid Avenue. The property is zone F flood district, which currently does not earn any signage. So any sign, no matter how big or how small that they propose, would require a variance. So here is the subject property on the south side of Euclid Avenue, just immediately to the west of the Des Moines River. If you see the blue lines here, the blue represents the extent of the flood district, the F district. And when the city established the F district back in 2019, we set the flood district to match the 100-year FEMA designated floodplain. So prior to 2019, this site would have been zoned C4, which would have earned signage. However, they're now zoned flood districts, so they no longer earn any signage. Here is a diagram of the signs that are being proposed. You can see of the 4 signs, one of the signs would be for the River Plaza sign, which would designate or identify the entire building. This site is known as the River Plaza. And then the other 3 signs would each identify a certain function of the JAPA entity that would occupy these spaces. Here's a sketch that shows where the signs would be placed on the building. You see it's generally in the middle of the north facade of the building. And then here are the official diagrams of the signs. Again, this River Plaza would identify the commercial center, whereas the other 3 would identify the specific tenants. Then here are some site photos. I wish I would have taken a better photo of this monument sign, but just for I wanted to point out that there is an existing monument sign along Euclid Avenue. This monument sign would be considered legal non-conforming since it exists today. They would not be allowed to add any new freestanding monument signs since the property is zoned F, but they are able to swap out sign faces on this existing sign. So they could put the tenant on this existing directory sign. Here are a few more photos. You can see there's currently only one other wall-mounted sign on this building, and that's for a church that would be just to the west of the 3 tenant bays that JAPA, the applicant, would occupy. This is looking more head-on. And then just 2 more photos of the building. looked like the other tenants in the building have tried to get around our sign ordinances by just doing window signs rather than wall-mounted signs. Then the staff recommendation is provided for you. Since these are variances, as the board knows, the criteria necessary for granting variances are very strict. They're very hard to demonstrate. They need to meet these three criteria right here. One, that the land in question cannot yield a reasonable return from any use permitted by the regulations of the district in which the land is located. And it goes on to say that failure to yield a reasonable return may only be shown by proof that the owner has been deprived of all beneficial or productive use of the land in question. It is not sufficient merely to show that the value of the land has been depreciated by the regulations, or that the variance would permit the owner to maintain a more profitable use. So we don't believe that they've satisfied those criteria. So we have recommended denial. I don't believe we've received any comment cards or letters from any surrounding property owners or neighborhood associations. So did anybody have any questions for me?
Questions for Bert?
Hey, Bert, Mr. Chair, this is Cindy. I have a question about the reasoning behind not allowing any signage if it's in a flood district. I must have missed that somewhere. That seems pretty onerous.
Yeah, and I will maybe let Sue Ann speak to that, but right now, the way the code is drafted, it does not allow for any signage for a property in the flood district. So to get around that or to change that, it would take a code amendment that would need to be vetted by the Plan and Zoning Commission and then ultimately approved by City Council. So if the appeals are denied today, that would be an option for the applicant, would be to potentially pursue that.
Okay. Bert, I have a related question to that. Is one of the reasonings behind not allowing signage is, in essence, we don't want to see uses in a floodplain expand further or become more entrenched? Is the idea that eventually, with a high chance of flooding, we'd like to see these things like not be there?
Right.
Is that one of the reasons?
Yeah, I think you hit the nail on the head that the intent of the flood district regulations is so that the existing uses there would eventually phase out, and it would, resort to or convert to more, I guess, just floodplain uses like parks and open space. So okay. I think the regulations are intended to not prolong any commercial uses in the flood district.
Okay, all right. Would you say, Bert, for active commercial properties in a flood district, is this kind of a rare occurrence in Des Moines? I know that's a tough one to throw at you, but
it is a tough one. But prior to 2009 or 2019, our flood districts were really limited to the major rivers, along the major rivers. However, in 2019, we used the creation of the new zoning map as an opportunity to get our flood districts to match the FEMA designated 100-year floodplain, which I personally think is the way that it should be. I think we need to have the flood district match the FEMA designated floodplain.
Okay.
So I do know we have the properties on both sides of Euclid Avenue here, and I know we have some others on Hubble Avenue where we have existing commercial properties that are now zoned flood district.
Mr. Chair, I have a question for Bert.
Go ahead.
Thank you. Bert, you mentioned across the street. I mean, isn't across the street, Polk County has quite a few organizations out of there?
Yeah, that in the city has our housing functions out of that building as well.
Yeah, and all those, I mean, they have signage up, don't they, in all those buildings?
Yeah, and that all predated 2019.
Okay.
So it was installed in accordance with the zoning regulations that were applicable at that time.
Sure. Okay.
But you can see from the map here, the blue line represents the flood district. So everything on the north side of Euclid in this area is also zone flood district.
Okay. And Bert, you'd mentioned, and I don't think your intent was malicious, but you had said they got around the sign ordinance by putting stuff, in or behind the windows. Now, it is legal to put signage behind your windows if you want to affix, sticky letters with your address, or your name of business, or hours. That's okay, right? As long as it's on a translucent window.
And prior to 2019, we did allow that, but now with the new code, we do require permits for window signs. And the intent of that is to make sure that the window signs don't cover more than 25% of any window.
Yep. So there is the ability for a tenant, because they all have windows, there would be the ability for them to identify who and what they are. After you've turned in the driveway, seen the monument sign, you'd probably be able to get directed to your tenant bay, correct?
Yeah, I'm going to look real fast. I'm not so sure that those window signs are allowed, though, in the F district. I'm going to look real fast.
Okay. I know that's kind of a tough one, and if you need a few minutes for that,
I found it, and
got it. Okay.
They are allowed. They fall under signs allowed in all districts, and signs in or on windows is within that category. So
all right,
I would interpret that to mean that they are allowed in the flood district.
Okay. But again, it's as long as it doesn't cover more than 25% of the window area, correct?
Right.
Okay. All right. Any other questions for Bert? Okay. All right. Then what we'll do, we'll go ahead and hear from the applicant, the person who's applying for the variance. I will just need their name and address, and they've got up to 10 minutes to address the board with the reasoning for their appeal.
I believe that Noah Tabor has his hand raised. I've allowed him to unmute himself.
Yeah, Noah, if you're on Zoom, just
yeah. Can folks hear me okay?
Yep. We just need your full name and your appropriate address, and you've got up to 10 minutes.
Thank you, sir. I appreciate that. Again, my name is Noah Tabor, Tabor, and I'm a volunteer with JAPA. My home address is 1606 Northwest College Avenue in Ankeny, Iowa. I'll be brief in my comments. I have some other folks with JAPA and the property folks as well on Zoom today, so they can certainly fill in more detail. Mr. Chair and the board, thanks so much for the time to speak today on this important issue. Really appreciate staff giving a good kind of primer on this topic. As was alluded to by members of the board in the conversation, this is just not a great solution to a problem here. That the ability, this building exists, signs should be available to have reasonable use for this building while it exists. I think there's certainly a hardship as JAPA works to serve the underserved homeless population in Des Moines. I think having signs is a wonderful way to live into JAPA's mission and the mission of the city to provide resources for these individuals. I think a mere sign or name on a monument sign is not sufficient for the folks that we are trying to serve. They are often transient. They are commuting via bus. Why are we putting more hurdles in front of these tender Iowans to find the resources that they need? Not to slight other businesses of commercial use, but this is not simply going to a salon. This is not simply going to a pet store. This is not simply going to a tavern. These are folks seeking assistance for food, for healthcare, for job resources. I think it's important to appreciate kind of what these signs are intended to do. We have read the code, we understand the code, we understand the owner's provisions that we must meet. but in looking at what is reasonable in the situation, what are the hardships in the situation? Again, I think allowing us a variance to have our signs up in the, yes, while it is a floodplain, while yes, there are new city ordinances, allowing us this variance, because without these signs, these buildings are for us is ineffective. That even if it's a window sticker on, on the inside of a window, our folks need to see loudly where they can come for help. We shouldn't trust that they caught an eye glimpse quick passing on a bus. I think this is important for missional work for JAPA and for the city. So we're asking for an equitable solution. This is my first time speaking to this board. I have listened all day. You are all good problem solvers. You help think outside the box. I appreciate that. That's a wonderful mark of you all. I am asking you to kind of use those same problem solving skills to help us. I think the solution we seek is an equitable one of allowing us as variance to put our signs up to help us to continue to do the good work of JAPA. With that, I will stop rambling here, and I'd like to recognize, and Mr. Chair, you certainly can run the order of things, but Joe Stevens, the president and CEO of JAPA, can speak more about the missional work that they do, and I think Joe would have some good perspectives for you all to hear from.
What I would say on that, if you're through with your testimony, we can have those speak in support. They can have up to 5 minutes apiece. The main thing that this board is interested in is the provisions of the city ordinance, the applicability of the ordinance to the site and the specific issue at hand. So
yeah, well,
do you want to have Joe just give us 5 minutes of his testimony?
Yeah, I think that's just fine. We can proceed that way. I can wrap up my appellant testimony at first, and then we get to supporters. Joe and others can speak.
Yeah,
that's just fine, sir.
Yeah, I think that would be helpful. So, and for your benefit, Noah, then would you be willing to take a question or two here?
Yeah, certainly. Again, kind of in kind of a quick conclusion of my kind of opening comments. Again, I know it's a high standard. What reasonable value, what reasonable return could be had. It's so important to have these signs for what the work that we look to do. Again, this is a commercial space which is beyond commercial use for us. And I know, I work at the Capitol, I know the code, I know kind of dealing with, we work in strictures, but working through the exceptions, working through the leeway and the variance as possible is again important for us. The building exists as it does now. And while we work, I appreciate the city's interest in trying to phase out or curtail kind of expanded use in floodplains. We are kind of between a rock and a hard place with being newly zoned as a floodplain, even though the building hasn't flooded in 100 years, and the new city ordinance is saying no signs in that place. That just kind of puts us in an unfair spot. And again, we are looking for an appeal to be granted to kind of help kind of rectify this imbalance. But yes, happy to take questions, Mr. Chair.
Okay, all right. Well, Noah, I'm assuming that you're one of a number of tenants in the building, so and I'm not sure that we'd be able to do this, but there already is a sign up at the right of way for people to see by bus, or if somebody was going to drop them off, or if they are homeless and they're walking down the sidewalk, they'd see that monument sign. So if we said, fine, you can put a sign on the building, but take the monument sign down, would you be okay with that?
Sir, I don't think that's sufficient. I think I appreciate kind of the role of a monument sign, but again, I think it's important to remember the tender population that we serve and the challenges that they have in transportations, the challenges they have with healthcare needs in terms of being able to see and commute and things like that. And I think it's important that we don't put further barriers in front of them. I think in a standard situation, a monument sign perhaps would suffice. I think then this is a unique situation because of the population that we serve.
Okay, all right. All right, that's my only questions. Any other questions for Noah?
Mr. Chair, this is Cindy. I believe JAPA used to be down at the Market District. Is this the new location they're moving to? Maybe I have that all wrong.
And ma'am, this is Noah Tabor. I'll let, when we get to further proponents, Joe Stevens, who's CEO and president, can more aptly speak of JAPA's history in terms of logistics and buildings. I don't want to overstep.
Great.
That sounds great. Thank you.
Yes, absolutely.
All right. Any other questions for Noah? Okay, all right. Well, we'll go ahead and recognize Joe and he can help fill us in on some of the things Noah's alluded to.
Thank you. Can you hear me?
Yes, sir. Go ahead.
Great. This is Joe Stevens, 2326 Euclid Avenue, Des Moines, Iowa 50310. We're in that same building location. If you look there, we're in that part that says Joppa on your screen over the River Plaza, as well as off to the right, the Homeless Resource Center. Thank you all for your expertise and for your the time you're taking to consider this exception or variance. We were located in East Village for 10 years, and we did recently move. We moved just before COVID, thank God, and we got into this building on March 1st. So since then, we have been investing in this location, and I'll tell you a little bit more about that in a second. But with all due respect to staff's recommendations, this project is absolutely critical to Joppa. Joppa is an organization whose goals are in alignment with the city's goals, as well as the county's goals, and both the city and county support our efforts to help end homelessness, as well as our plans for this particular location. And so Joppa is in the process, since we moved in last March, of investing $750,000 at this location to build Iowa's first homeless resource center. And that'll be a one-stop shop for providing immediate services, as well as referrals to all the existing services in town. We have caseworkers. We're going to have a customized plan for each individual to get off the streets. We've already helped over 450 individuals since we've started get off the streets, and we're still at over 85% remain off the streets. And so we have a system that includes aftercare, that includes all the right wraparound services to be able to help people get and stay off the street. And this is our effort to have a one-stop shop. And so the number of homeless people in the area is surging right now. You guys have probably seen it as you drive around on the streets. Joppa is in its 13th year, and I've never seen more homeless people on the streets than I see now. And so we've been trying to get the data around that. We do a lot of, I can give you more data, but here are a couple of stats that you might find interesting. Out of the 125 people that we interviewed that are homeless, that we interviewed in the last 60 days of last year, 32% of them, 40 individuals, were first-time homeless due to COVID. We were already seeing an increase in homeless people due to the affordable housing crisis before COVID hit, and that's just exacerbated the situation. Eric Burmeister from the Polk County Housing Trust Fund can tell you that he and Angie are down there fighting evictions, and there's literally hundreds of them on the dockets every week. And they're fighting the good fight, but we're not winning in all those cases. So we're having so many people evicted. They need to know where to go. They need to know about this place, and word of mouth will catch on once they see the signage. But there's no way for us to advertise to people that are on the verge of homelessness or experiencing homelessness. So this is really partly prevention, and it's partly also giving those folks the resources. So they can't discover and find us without a sign. And the city of Des Moines really needs this resource center now, not sometime in the future after we go through some other alternative process or something, and then hopefully prevail at a later date. So we simply can't open and operate this new resource center without a sign. Secondly, and I'll be brief, we're opening the what we call Thrift Mart right next door, which you'll see on the sign there, which is a wholly owned nonprofit store to provide the community with a high quality thrift store, as well as provide a sustainable source of funding for Joppa and job training as well for the Homeless Resource Center. And this is a thrift store that will be paying sales tax. It's something that, the council, the mayor support at this location. And opening a retail store without a sign is like having a McDonald's without a sign, only it's worse because it's a brand new brand. It's a brand new store that no one even knows about for the community. So opening the store just is simply not viable without a highly visible and attractively branded sign like the one you see on your screen. And not allowing an exception or variance at this meeting today was going to result in a significant delay or even the cancellation of the Homeless Resource Center and or the Thrift Mart store. And, all these are privately funded nonprofit ventures that are intended to provide that we're intending to provide, and as well as the potential loss of the some or all of our investment that we put into this location. So I'm very concerned. On a side note, the existing marquee sign out by the road that was mentioned is not lit. It does contain 4-inch lettering that is, you can't see it when you're traveling westbound from across the way, and you'd have to be looking for it. It's probably not safe to be looking for it if traveling eastbound. So no one will know we're there. They won't be able to find us. And a sign behind the window, you'd have to already be in the parking lot, like you said, to be looking for us at that point. We're trying to get people to discover us and to get the neighborhood to know that we're there and providing these resources. So, you know, that's the real issue. And the bottom line is that we simply can't operate. You know, we just can't open either venture, much less successfully operate them without signage. And so this location becomes pretty much worthless to Joppa without the signage. And so I know the landlords have contributed to our build out, and we've had a number of private investors. Mid-America Energy has contributed $150,000 to this venture. And I can give you more details. I'll be happy to answer questions, but we need your help. And so thank you all for your consideration.
Joe, would you be willing to take a few questions?
Absolutely.
Okay, board members, I'll defer to you initially. Any questions for Joe?
Mr. Chair, this is Justin Gross, if I can.
Yeah, go ahead.
All right, thank you. Joe, you said you've been in this location since March 2020, is that right?
Yes, that's correct.
And have you been seeing clients since March 2020?
So Joppa has previously been about outreach. And so we go, part of, you know, what our organization historically has been going out, and that when we operated from East Village, we weren't allowed to have clients at our location. So this is something new. We'll have people, that have heard we're there, stop by and knock on our door, but no, we've not been able to operate at this location with this new, we've never had landlords willing to allow us to have a homeless resource center or to allow folks experiencing homelessness to come into our facility. So, this is brand new, and we do operate, our outreach out of the back part of the facility, but being able to open the front part, which we've, invested in a bathroom, and I can tell you, phone charging stations, and like I said, caseworkers, computer stations, we're ready to go. And we just cannot, and we're not able to do that without the signage. I'm not sure did I answer your question?
No, you did. Yeah. I was wondering if you were seeing clients, if you anecdotally could tell us of people having a hard time trying to find the new location.
Yeah, we haven't really, we haven't really let people know that we're there and that they're welcome to come. And so I can't really speak to that. I can tell you that we've had volunteers and donors that have had a hard time finding us.
Okay.
Got it. Thank you. Thank you, Joe.
All right. Joe, this is Mel Pins here. Just a general question. I realize you're not the property owner here, but I know there's a number of tenant bays here. To the best of your knowledge, are there a lot of vacancies in there? Does a lot of this property kind of sit underutilized? What's been your general vibe of what you've seen since you've been there?
And I believe the building owners will be speaking here in a little bit, but my understanding is we've taken the last space. The Thrift Mart was the last space in the building, and it's fully occupied now.
Okay.
And I can tell you Broadlawns is there, and there's another social services type organization at the other end. I believe they're called One Side. I'm sorry, that's slipping my mind right now. And of course, Vineyard Church is right next door. Everybody in the building is supportive of what we're trying to do.
Okay. All right. Thank you. All right. Any other questions for Joe? All right. Okay. Is there anybody else who wishes to speak in support of the applicant's request? Hit the raise hand function in Zoom or *9 on your phone. Who do we want to recognize there, Bert?
Kevin Kraus.
Go ahead, Kevin.
Should be able to unmute himself. There we go.
Can people hear me?
Yes, sir.
Thank you for this opportunity to visit with you. My name is Kevin Kraus, 5601 Hickman Road, suite number 3 here in Des Moines. And I am one of the owners of the building. Another owner is also on the phone. That's the degree of interest we had in this and the support we have. We totally support what has been said before. We're very excited to have Joppa in our building. We really feel that if they are unable to have these signs, they would not be able to lease these spaces. That would be a financial detriment to us. we like to have the building, they have about 20,000 square feet, which is about a fourth of the building. And that really allows us, not as a matter of really having a more profitable use, but just being able to get to a profitable use. It's difficult to operate a building when you have that much empty square footage. And it was empty for quite a period of time. It is a difficult location, but this location so much matches Jopa's mission. And we have committed our resources in terms of tenant improvements to help them in their situation. We want to maintain the building. We think the building is in very good shape. We've put tremendous money in the parking lot, in painting the building so that it looks good from the street. We think these signs are where previous signs were located, where signs are intended to be on this building, or if the building was 10 blocks down, they would have signs in these locations. While the building has been now classified in the flood zone, I would make the comment that we hit the flood zone by inches. I think it's only like 2 or 3 inches that we're within this flood zone. We have not flooded. Our ownership group, we've owned the building since 2002, and we have not had any flooding. We are not aware of any flooding prior to our ownership. We know we are a little bit higher than across the street where Polk County is, where they did experience some flooding in the past. But we think this signage is so critical to what they need to do and what we want to be doing with them. And we would really respectably request you to consider providing us a variance.
All right. Questions for Kevin?
Kevin, this is Lynn Carlson. You said you put some money into it because it does not look like it used to when I was going through there. So you have put considerable amount of resources into upgrading it, making it look nicer. So when was that done? And also, were you aware of the flooding across the street in '93? And was this building affected in that? So those are my 2 questions.
Thank you. It was not affected in '93. While we may look like we're comparable height-wise, we are actually the building sat above the 500-year floodplain as it was when it was designed. As far as improvements gone, probably roughly 5-6 years ago, we spent almost $250,000 putting a new roof on the building. I mean, that's one of the things that we kind of commit to. We operate our buildings that we would, we want to operate them in a safe, secure, clean manner. We've also replaced concrete. We probably spent probably close to $250,000-300,000 on new concrete, the approaches off the street. And we're doing it with, concrete that'll last longer, not just doing patching. There is work to be done. I will admit that. I mean, you look at the picture we're looking at now, there is some cracking and things. I mean, this is one of these things we can't do everything in a single year. Back to operating it on a profitable manner. By having Japa and being able to have them will allow us to do additional projects to continue to have the building be a strong presence there. One of the things we did, we had the monument sign was probably about a $20,000 sign. And previously, if you recall, there was a tall, probably a 20-foot, it wasn't an attractive sign at all, but it did a very good job, I mean, because it was so big. But we thought this is one of the things we said, that one wasn't attractive. So we're trying to continually invest money to make it attractive on the site and for tenants.
Thank you.
You're welcome.
Other questions for Kevin? Kevin, this is Mel Pins here. The city staff photos are generally taken from the public right of way, so they're not unduly on private landowners' property. But I'd like to get a better feel for the whole building here. How many tenant bays are there? Do those tenant bays have signage above their entrances? I mean, from this picture, I can't even tell how many entrances there are. Taking Japa's mission aside here, do you have, I was surprised to hear that basically you're fully leased out. So do you have tenants who don't have signage on their building, and is that hindering them? Can you kind of help describe the property and who has
Certainly.
signage and who doesn't?
Certainly. Well, I'll tell you that the building, again, has a large parking lot here. It was originally built as an Ardennes back in the day. And so it does have probably a larger, like I say, a large parking lot that takes a lot to take care of. On the end, we have broad lawns, and they do some patient billing, and then they also have their WIC program there. They have a sign on the street, but they actively do not want a large amount of signage because they don't want people, if they see broad lawns, they may think, that they have drugs or something else there. And their focus space is where they serve their customers. And they're closest to the river. Coming towards us would be Modern Bike, which you saw. They have an internal sign. They did the internal sign more from a cost effectiveness versus choosing to put one on the sign. Their business is probably about 80 to 90% internet sales versus walk-in traffic. So it's not as important for them to have the signage as a destination customer.
Got it.
Then the middle is Joppa. Again, we're talking there that they're more of a destination location. And then Vineyard Church does have the signage that you see in this picture. And then on the end is a organization called New Site, and they have specific, after school youth counseling. They are not in need of signage, again, also because they are, they don't have walk-in traffic or type of thing. So, yes, it's, this will be the first time, that we will be fully, we had the vacancy probably for 7 or 8 years, which again, it's really, like I say, the difference between being able to pay the bills. When we have the vacancy, our insurance, our snow plowing, our property tax, our mortgage payments, they don't decrease. So a lot of our bills stay the same. And so by being able to attract the tenant, we're able to do the things to make the building attractive and a positive aspect of the neighborhood.
Right. Okay. All right. Thank you. That really helps for an explanation on your setting there, Kevin. Thank you.
You're welcome.
All right. Any other questions for Kevin? Okay. All right. Is there anybody else that wishes to speak in support of the applicant's request? Looks like maybe Miranda, our sign designer. Okay. Miranda, I think we'll have Bert go ahead and recognize you.
Yeah, there we go.
Hi, everyone. This is Miranda Cassins again with Chestnut Signs at 971 Northeast Broadway Avenue, Des Moines, Iowa, 50313. Thank you for listening to me again today. I appreciate it. I'm mostly here to answer if you have any questions about the sign. I do believe that kind of my thoughts are you want to make the building inviting. They've done a lot on the building itself, making painting and doing parking lot repairs, adding the ground sign in and things like that. But when they're trying to draw in these customers and volunteers and homeless patrons, having the signage is not only going to make it so that it's easy to find, it's going to make the area inviting. It's going to improve the looks of the neighborhood because, again, when you see a multi-tenant building that doesn't have any signage on it, you're automatically thinking it's empty, it's run down. Even if it's starting to look improved, you're thinking, why is no one moving in here? But when you start to see those signs, you start to feel like there's life in the neighborhood. So I think that's very important. And then to speak to the monument sign, as mentioned before, it's more there just to identify when people kind of get there that there are these patrons in the place, but they're fairly small letters. Again, when they put that sign in, they were trying to come down from a giant sign to something more attractive, something that fit in the corridor a little better. And so I wouldn't say it's going to direct people to the various tenant bays. It's going to be very hard to identify where Joppa is, where Thrift Mart is, where Homeless Resource Center is, because when all those cars are in that parking lot, you can't see those windows. So the window vinyl while it isn't a solution, isn't really a very viable solution for this particular property. If it was a building that had 2-story windows that you could advertise above that could be seen, I could see that as more of a solution. But in this case, we don't feel as if there's really any other option than having the wall signs in place. So
Okay.
again, if you guys have any questions for me, definitely let me know. I can answer to the best of my ability.
Yep. Okay. All right. Thank you, Miranda.
Yeah.
Any questions for Miranda? Okay. Anybody else that wishes to speak in support, hit the raise hand function in Zoom or *9 on your phone. Looks like we have a Jack.
Yes, can everybody hear me?
Yes, go ahead, Jack.
This is Jack Sullivan, and I'm 5601 Hickman Road with BP Real Estate Group. I'm also one of the owners of River Plaza, along with Kevin, and we have owned the building for quite a few years and have consistently done a lot of improvements to the property. When we bought the property, it was in a relative state of disrepair, and the neighborhood at that time had Target across the street, and then Polk County moved in and did a significant amount of renovation to their building and stabilized the north side of Euclid. And as you know, there is a good deal of incentive to see improvements along Euclid. While we don't necessarily disagree with the overall ultimate goal of where they would like to go with Euclid, in the interim, which we hope is many years, is that this is a large parcel that has a significant amount of mental impact on people about what the quality of the area is for other retailers that are slightly up the hill. With the loss of Val lanes up the street, that's obviously impacted the area. And it's our goal to, as Miranda indicated, to make the center, because it is so large, have a vital and attractive presence to the community. In addition, obviously, to what JAPA's mission is. Kevin spoke to the fact that the other tenants and what kind of signage they have, as he alluded to. Broadlawns' functions that are there are more destination driven, as are the Vineyard Church, the new site. Modern Bike being 80-some% on internet, they don't necessarily need a lot of walk-in traffic, but they have a very nice facility from a distribution standpoint. Vineyard Church, their sign was critical to their success. And they said numerous times that if they had not been able to get that sign, and they had a great deal of fundraising inside of their church to get that sign, that cost them a great deal of money, and it has impacted the attendance prior to COVID a great deal. So the Thrift Mart is a retail location, the same as any other retail location across the city. And it does require good visibility and vibrancy to be seen. And we just kind of feel that River Plaza is in the flood zone, but it does still exist, and it does provide a significant anchor to the whole Euclid Avenue corridor. Mm-hmm. I feel that not only is that beneficial to the city, it creates a great deal of tax base to the city, as well as sales tax if the store was to be placed there. It also creates a significant hardship on our ownership group if we're not able to have tenant, we can't lease tenant spaces out if you tell them, well, I'm sorry, you can't put signs up here. So that impacts how well we can maintain the building. That's the net of it, is that we want to see JAPA successful. And when JAPA is successful, we are successful. And if we are successful, the city of Des Moines is successful in increasing property valuations in the area and so forth. We're very willing to take that risk of the cost of signage and so forth. We have flood insurance and so forth. We're willing to take that risk given the fact that we've always been in the 500-year floodplain, and we fell into the 100-year floodplain by inches. It isn't that we are anticipating feet of water in this building, because we've evaluated that with our own engineers. Mm-hmm. So we appreciate all of your time and your insight to how the city of Des Moines manages its signages and properties, but we feel we kind of have a unique situation here that we just need your assistance with. So that's all I
Okay.
have.
All right. Thank you, Jack. Any questions for Jack? Okay, seeing none, do we have anybody else who wishes to speak in support of the applicant? Hit the raise hand function in Zoom or *9 on your phone, going once, going
Don't
twice.
see.
Okay. How about anybody that wishes to speak in opposition to the applicant's request? Same signs to be recognized.
Don't see any.
Okay. All right. Anybody who wishes to speak in neutrality about applicability of signage in a floodway district on this property? Okay, see none. All right. Do we have any questions for city staff? Board members? All right. Hey, Bert, I'm going to throw one at you. I don't want to dig too deep into this, but since this is a floodway zone, and I know the ordinance is new here for some changes, but generally with zoning in a flood zone, if the building was damaged by fire or flooding and they'd have to pull a building permit and cost to repair or rebuild was more than, I think, 40 or 60%, no, it wasn't allowed. So would the same thing apply here now under the current ordinance? If the building was damaged to some certain percentage, would they not be allowed to fix it? Is that correct?
And Sue Ann can correct me if I'm wrong, but I believe that if the building was destroyed by more than 50% of its
50.
value.
Okay. So then how about remodeling? Because the owners talked about fixing things up and improving spaces. So if they're in this flood district, unless that happened beforehand, would there be limitations on how much internal work they can do on the building in the future?
Yeah, and Sue, do you want to address that? I believe since it's illegal non-conforming use, they could make improvements within the building, but they couldn't enlarge it. Or...
Okay.
Like chair members of the board, they can make improvements within the building to expand non-conforming uses into other parts of the building as long as they're manifestly arranged for such occupancy.
Wow, cool. Okay. But building additions wouldn't be allowed or stuff like that, correct?
Correct.
Okay.
And
All right,
I would also, they said something about doing renovations inside. I would caution them to come in and talk to staff about whether those renovations would require permits. If they're changing walls and opening things up, they better come in and talk to staff about permits.
And if somebody wanted to do that and the general value of that would be greater than this 50%, even though the building wasn't, quote, like damaged, could they make those kinds of, costly renovations that would require building permits to a building that's in this floodway?
I believe that under the non-conforming status, it does allow people to do repairs and to maintain the stability of the building. So I believe that would be okay. Like the roof, that can be done.
Yeah. Okay. So as long as they don't expand the footprint or add a second story, or it's not unduly damaged through fire or flooding, then yeah, they could continue to kind of keep things ship shape there to meet needs of tenants. Correct?
Yep. Absolutely.
All right. All right. Any other questions for staff? And Sue Ann, do you have any comments yourself as zoning enforcement officer?
Actually, chair, members of the board, I do.
Go ahead.
So the one thing I will point out is that we can no longer regulate signage based on content. And a lot of the arguments today were content-based, that with all due respect to JAPA and their mission, their signage would be no different than a hairstylist when you talk about signage, allowed signage, because you're not going to allow signage based on content. So they have to meet the variance test without talking about content. And I'm not sure that they've reached that threshold. I will say that in reviewing this and reviewing the code, I think staff is willing to go back and make amendments to signage in the floodway to allow signage that was recently removed from the code. It does seem rather odd that you have a commercial building in a floodway and you can't get signage. Signage isn't going to extend the life of the building necessarily all by itself. So that's the balancing act between allowing continuation of a legal non-conforming and allowing it to be used while it's viable. So my suggestion would be that they get 6-month temporary signage and help staff work on supporting an ordinance change to allow signage in a floodway.
You could have saved us a lot of time there, Sue Ann.
My turn wasn't until now. Indeed, the board itself could, make a motion to contact council to request that change, which then again would keep it in the forefront and get the change discussed. I think it's a reasonable request for an amendment to the code.
Related to that, the signage that was presented by Miranda, to the best of the city's knowledge, if this wasn't in a floodway district, would the signage as presented normally meet our requirements for the limitations on size and placement and all that? Would it have normally been approvable as presented?
I would assume that that the design would meet the code, but since we don't have any standards for this floodway signage, it's kind of hard to say.
Yeah, if it was in a comparable district like our earlier item on Merle Hay, would it likely meet those standards? And
I would assume so, but we have not, honestly, we haven't looked at it.
Gotcha. Okay.
If you don't mind, I can speak to that. It would meet the codes in the current DX2, DXR, MX1, MX2, MX3, CX, and RX districts. It is not exceeding the 1.25 square foot of signage per 1 linear foot of tenant frontage. So we did try.
Miranda, I figured you had that, so that's good.
Yeah. We did try to design within the neighboring zones and things like that, so that we weren't trying to push for something that was unreasonable.
Sure.
Very good.
Sure. Yeah.
Thank you.
I was just guessing that's probably the basis that Miranda used for her design. Yep.
I figured that too.
All right. Well, Sue Ann, again, you were giving your comments. So anything else you want to add on that?
No, that's it. I don't think they meet the variance test, but I do think we have other opportunities to get them signage.
Okay. All right. So do board members then, continuing on, if we had questions for city staff, Sue Ann's obviously here. Any other questions we'd have for the city?
Mel, I've got a quick question.
Yeah, go ahead, Dave.
You talked about the property, I guess, to the north, which is owned by the city.
County.
Or county, and they have signs. And the reason they have the signs is they were grandfathered in.
Those signs went up before the code change.
Yeah, okay. All right, perfect, thanks.
Yeah, nope, that's a good clarification, Dave. Okay, any other questions for staff?
Lynn Carlson here.
Go ahead.
I don't know if this would be Sue Ann or if it would be Judy, but you recommended giving temporary signage and going to city council to change it. Could we grant them the variance for this with the provision that would fit ordinary sign provisions, which Miranda already said it does, and then give a recommendation to the city council to re-examine this, using this as an example, but go ahead and give the people permission to go ahead and get started?
Mm-hmm.
You would have to find that they meet the variance test.
Yeah.
Yes, this is Judy. I would concur in that. To grant a variance, we actually have to meet the standards.
Yeah. Lynn, you've got a very good line of, well, hey, how do I unravel this issue? But yes, anytime we want to grant a variance, in making the motion, you'd have to give your reasoning. And again, that variance test, it's a very strong one. But if the board felt there was a good enough reason for a variance and that passed, then it would be approved. Of course, somebody could decide to challenge that in court. In this case, it would have to be the city. So yeah, that's
Send it
possible.
To the city to consider as an agenda item.
I think rather, this is just my suggestion as your fellow colleague, rather than ask the city about our potential approaches, I'd rather we discuss it as a board once we close the public comment.
Okay, thank you.
Yeah. Okay, any other questions for staff? Okay, seeing none, the appellant, you get 3 minutes for closing comments or a rebuttal. It can be one of you. I know we have JAPA, we have property owners, but it's a 3 minute in total. So if you've got somebody who can speak best on this, I'm guessing maybe that'd be Noah. And Miranda, we've already recognized you. So unless you're going to lead the 3 minutes here, I'd ask that you take your hand down. All right, let's go ahead and recognize Joe to close us out. Go ahead, Joe. And you may need to unmute yourself if staff has recognized you.
Thank you. Can you hear me now?
Gotcha.
Thank you. No, I apologize. He had a meeting with the governor and had to run. So I am gonna
Well,
wrap.
I don't know about that.
We have great, he volunteers for JAPA and we have great volunteers. And so
Yes,
we're very blessed that way.
Great.
So we do, just a couple of comments. We do have a permit for construction. We are investing $750,000 in the facility, where Edge Construction is our construction company, and they're doing the general contracting pro bono, and Mike Simonson did all of our architectural work, and we did work with the city to get the proper permits, and we're nearly complete. So we've already invested the money. I don't know, as I understood it, the proof for the variance is hardship, right? And the inability to operate.
Mm-hmm.
So, I mean, I don't know if we're just not communicating well, but we simply, we can't open this store. And with, the Thrift Mart store, a temporary sign, is going to be more cost and more delay. And then, I'm not sure what that allows, but, I'm picturing a banner or something temporary that's just not going to work for a new store. That's going to make it look like it's not viable. It's not the kind of experience that this brand's going to have when it launches. So we're just not going to be able to launch with, and that's going to delay, that just really, it pretty much makes our whole model and our whole business plan untenable. And so that will cause us to need to go back to Kevin and Jack and talk about, can we undo this lease, and what will they do in that case? And then where do we go to put this store in the meantime? It's just not possible to operate without the sign. So, and as far as homeless people finding us, if the temporary sign were big enough, maybe they could find us. But again, we're wanting people to drive by to discover us, to talk about the fact that we're there for both ventures, and to want to come and visit. And I just don't know how I would feel about visiting a place with a temporary sign, that claims that they can help me. It's just not what we're going for here. We're an organization that does things with quality, and we're trying to help end homelessness. So I would like to think that we have met the proof of hardship for the variance. And if there is a possible way that you could grant us to go forward with the signs as designed, and then, we would be glad to work with the city, or to go to meetings and help promote the reasoning behind how the code needs changed, or whatever you guys are recommending. But we really need to put this signage in place as designed in order to carry forward with our plans, and otherwise we are in serious trouble. So,
yeah.
So I hope that we've proven that, met that hardship or variance requirement, and I'd be happy to answer any additional questions.
Okay, well, this was about closing rebuttals. So, so you got to wrap it up. So thank you, sir.
Thank you, sir.
Yeah, we'll go ahead and close the public portion here and go to board deliberation. So folks, this could be a straight up, straight down thing on variances. It could be with a variance, you've got to meet the strict test. And we may be able to briefly discuss related or separately if we would like to ask the city to take some other action to review applicable city ordinances. We always have that right to do that. In our training this morning, I was reading ahead, the chair can even call a special meeting. Cool. So I would say let's focus on the issue we've got at hand, which should just be my discussion suggestion. And then maybe we could talk about some additional things, but those are just my initial thoughts about approach, not the merits of the case. So thoughts from you all?
Hey, Mel.
Yeah.
Hey, this is Dave. Can I kick this off?
Sure.
I think they presented a pretty good case. And I think what this sign, based on their mission and based on what they've explained, is they're trying to create a sense of arrival for a part of the population that needs a lot of help. There's multiple projects going around town other than what JAPA's doing to try and help assist and deal with this homeless situation. So the fact that the county's got a building across the street that's grandfathered in, I feel like these guys are stuck based on a timing issue. They put a lot of money in a property that sits way off the road. There's a monument sign out there that basically, I mean, I don't know what the speed limit is along there, but when I drive along here, I bet I'm not going less than 45. Hopefully there won't be any eating traps out there. But anyway, I think what we need to do is let's let them put their sign up. I don't think this is that big of a deal. Let's not get them bogged down in the current city ordinance. Let's have the council review this, but as we've done previously with signs, this is not a one size fits all. And I'm not opposed, and we've made some tremendous improvements to this sign ordinance. And I'm kind of talking out of both sides of my mouth a little bit because I vote both ways on this, but what I try and do on every agenda item here is let's look at, what's in the greater good of the community and what can we do to make this happen or not happen and why. And we've had several examples of both today. So I'm inclined to make a motion. I'm not going to yet because I want to hear everybody else's comment, but I'm inclined to make a motion to say, let's let them put their sign up. And then if we need to put this in front of the city to get the ordinance changed, fine. I don't think we need, because I think we can rule on this. And I'm going to say they've given me enough of a reason to say, I think they've met the variance on item. So those are just some of my thoughts. But here again, they're trying to create a sense of arrival for a group that's going to be on foot, on bikes. They're going to be, coming from the bus.
Yeah, because Yep. Okay.
Anyway.
All right. And folks, and again, I'm speaking as a colleague here, but also the rules of the game between us as colleagues. JAPA's mission is extremely important, but the zoning ordinance does not look, again, at the content of the signage. It looks at the applicability of the signage in the context of the zoning ordinance. So whether this is Dottie's Donuts, dressmaker, or let's say Mel's Hobby Shop wants to go in there, would a variance be reasonable to allow a sign on that building based on the variance test? So I would encourage you to kind of focus on that. Yes, I know their mission's important, but look at the bigger picture, especially if you want to help out the issue here, because what we need to do is focus on the variance test, not on the mission.
Here, this is Joe. Go ahead.
Yeah, Justin, go ahead.
Okay, I know I think it was Marlis after me, but I just want to say, yeah, I've been aware of JAPA for many years, and I know they do good work. But as Mel pointed out, we have to focus on the variance criteria, and I mean we are in a tough spot. The F designation seems to be very harsh, but we are as board members bound by the variance criteria. And to Joe's question, he would have to show or prove that the owner has been deprived of all beneficial or productive use, and that is not met here. So I would be inclined to say no to the variance, but I do want to help. And I think the suggestion by Sue Ann Donovan to allow for a 6-month temporary signage and then direct legal to amend the F designation to allow signage would be the proper avenue here. Thank you.
Yep. Other thoughts from the board?
This is Lynn Carlson. My thoughts are this building has been improved greatly. I drive when I'm out and about usually this area for a great time. And 10 years ago, it looked like a rundown place, not a place I would want to stop, not a commercial building. The owners have put a lot of money into it, maintaining it, improving it, and it looks as good or better than any other commercial strip mall. Other strip malls are allowed signage, and therefore I think this one should be allowed the proper signage, and we should give them the time to do it right now, immediately, rather than wasting more time having the city council change the rules and having to go through the expense of temporary housing. So my reasoning is that it looks like, and it has been maintained like any other mall that's allowed signage. So this one should be 2, whether it's Dottie's Donuts, Mel's Hobby Shop, or Lynn's Liquor Store.
Yep. Do you have a conditional use permit for your liquor store, Lynn?
I have to make arrangements and talk to people first. But those are my thoughts. And so, whatever.
Yep. Very well spoken. Other thoughts?
This is Cindy, and I tend to support Dave's comments in that I believe that they've made their point for meeting the variance.
Yep. Yep.
And we've, like you said, Mr. Chair, initially earlier today, that, we need to look at every case because every case has different merits.
Right. Yep. Marlis, did you want to throw in anything?
I guess we are doing a roundtable, aren't we?
Yeah, I think it's good to have a good discussion on a few of these key issues.
I totally understand how terrible the homeless situation is, but I have to stand with Justin on this one that, we do have to follow what our ordinances are.
Okay. Well, I'm going to round the bend here a little. So the variance test is a tough one, and it's there for a reason. But I see a case like this one with the potential to meet the variance test for a number of reasons. First of all, I'm not going to be a constitutional lawyer here, but I think the legal intent of the flood district was stretched a little too far here with an ordinance that's pretty draconian. As has been stated, expanding a use with new construction would not be a good idea in the zoning ordinance. That's not allowed. Repairing a building that's been flooded or damaged by fire by over 50%, that's also not allowed because that's not a smart thing. We don't want to see those kinds of investments. But prior to December of 19, this property was a shopping center commercial district zoning. That kind of zoning would have certainly allowed for tenant signage above those tenant bays and those major entrances on the facades of the building. And I know it was converted to a flood zone, but the general use of the property was for that kind of commercial retail. And when we look at the variance, it says, the land in question cannot yield a reasonable return from the uses permitted on the property. Well, the uses are commercial. He said they had 7-8 years before they even got a tenant in there. And they sound like very nice owners. They're probably being too nice. A lot of the tenants they've got are they're probably giving them a break on rent. or it probably the amount of square footage being charged isn't very much. I doubt whether they're making much money on this place, but I'm not here to argue for that. What I would say is we're going way out of line if we won't allow a person who pays 100% commercial taxes on a building to be allowed to have a commercial sign. I kind of think we're throwing common sense out the window. If they had a whole bunch of pole signs and wanted a huge sign and Miranda wasn't designing it within parameters, I'd say no, meet the requirements. But I think we have a reason here to grant a variance in this case. And then the board can go ahead and do a little extra lifting and requesting and ask the city to relook at their ordinance so we don't have to have these kinds of cases in front of us again. So we've got 6 members here. If somebody does or doesn't meet a variance test, that's the discussion that we've had, or if there's a motion one way or the other, that's the defense people will have to give it, and we can see how it goes. But does anybody else have any other final thoughts or motion?
Hey, Mel, I'll just make a motion, to grant the variance.
Okay.
I'll second that motion, Dave. Mr. Chair.
All
This is
right,
Cindy.
and just as a friendly thing, Cindy, before your second, would you want as a condition that the signs must only be installed to meet comparable city requirements and comparable commercial districts based on size and scope of the building? So in other words, they don't come at us for turn around and have an exception for a sign that's a little bit larger than in other districts. Because as Bert said, there are no allowances in a flood district for a sign. Does that make sense?
I absolutely think that's a perfect addendum to the motion. And also, Mr. Chair, I'm not sure if it would be an addendum or not, but I would like to see this whole issue go back to City Council for reevaluation for floodplain districts.
Yeah, let's separate that for the time being, and on the agenda, when we get through with our agenda items, I've got the ability to ask that, and we'll ask city staff what we have to do.
Thank you,
As an
Mr. Chair.
example, this board wrote the letter with Chairman Bill Gray's signature to ask the city to implement a monument sign ordinance and to get rid of the pole signs allowances. So that was an action that this board took. I think there was support from staff and the council, but we in essence pulled the trigger on that request. So I think we can do that, but we can do that under a separate item. So there was a motion by Dave, second by Cindy, to approve the variance with condition that any signage must meet comparable standards in other districts based on size and scope of the building. Judy, since you're on our side of the bench here advising us, and we're in discussion and potential voting here, is that clear enough and defensible enough on what of how the signage would have to be constructed?
Yes, I appreciate you putting some direction in there, because just granting a variance without any direction is going to be very difficult to figure out what you meant. So yes, that should be fine.
Okay, great. Okay, all right. So we've got a motion and a second to grant the variance to allow some appropriate signage on the building. So we'll go ahead and take a roll call. If you're in support, you'll be an aye. If you're against, nay.
Marlis Jones.
Nay.
Sorry, what was that again?
Nay.
Nay. Cindy Smith.
Yes.
Lynn Carlson.
Aye.
Dave Gare.
Aye.
Justin Gross.
Nay.
And Mel Pins.
Yes.
The motion carries 4-2.
Okay, good discussion by all. And what I would say here for our gang from Joppa, give staff until next week to put that decision in order together, but then you're probably going to want to sit down with them and your sign designer and talk through this. So from that perspective, they should be happy. So that'll move us on now to item number 11, a zoning exception request at 2525 Easton Boulevard.
We're done.
Chair, members of the board, Jason Van Essen with the city's planning staff. We are considering a type 2 zoning exception to a time period within which a use may be resumed after temporary discontinuance of that use. This is regarding a pole sign. Let me, here we go. Aerial identifying the subject property on the southeast corner of the Easton Hubble Avenue intersection. Site contains 2 buildings with multiple tenant bays. The signage is along Easton Avenue. Photographs of the property. There are 3 pole signs on the property currently. This Medicap monument sign is actually on the parcel that adjoins it, but the subject property is these kind of strip buildings you see, and there's 3 pole signs. The subject one is in the middle of the site. Then the last sign, it's a little hard to read, but there actually is signage there. And then I have some photographs from the code enforcement documenting that the sign face was not, there was nothing on the sign, it was not being used. This is December of 2019. Both sides of the sign. And then December of 2020. The applicant or the application, I have a few things from that to share with you and we can come back to if needed. But this particular pole sign in the middle of the site has been utilized for the space, empty space that's in the building, had been occupied by auto repair business. The auto repair business in 2018, there was an enforcement action. There have been complaints that there was inoperable vehicles and outdoor storage. As staff visited the site and did its due diligence, we found that the use did not have rights to be there. The property at that time was zoned C1, which did not allow auto repair. With the adoption of the new code, the MX3 zoning does allow it, but in 2018, it was, I believe by the end of the year, the tenant had left the site. You'll recall that the new zoning code and the map, we worked on that adoption in 2019 with that coming to conclusion at the end of the year. Just the addendum from the applicant's submittal. We have a lot of this information and some slides that they've submitted that we'll have available for them to present when they speak. Staff reports with the criteria that applies. In addition to the standard exception criteria that we're accustomed to looking at and referencing in our reports and review, the exception to a time period also has this extra criteria that we're supposed to keep in mind, that in addition to the kind of the standard language, and that's discontinuance of the use was due to unique circumstance, not of the property owner's own making, and that resumption of the use will not alter, or excuse me, will not have a significant adverse impact on the essential character of the surrounding area. So these 2 criteria have to be met in addition to the other ones that we're accustomed to. We are, as staff, recommending denial of the request. Staff rationale, we identified that there's feasible alternatives to providing signage for that tenant space, which would be a monument sign if they want it freestanding. There'd also be building mounted signage allowances. That when we contend that the visual clutter created by pole signs have a significant adverse impact on the essential character of the surrounding area. And that's why that they are no longer allowed by city code. And the intent of the zoning ordinance is for non-conforming signs to be replaced as they lose their non-conforming status to mitigate that adverse impact. I do have response map showing the notice area, handful of response cards. With that, I'm happy to answer any questions you have for staff.
Sure. Questions for Jason? Hey, Jason, just a very brief one. If a new sign would be installed today, let's say a monument sign in the same position or placement as where the pole sign is, would that sign placement meet setback requirements?
You know, I off the top of my head, I don't know, but we would have to definitely evaluate that, both size and position and the number of signage on the property. But
I realize your concern isn't where the sign is placed now. It's just that it's still there.
That's
but
correct.
I'm guessing it's probably very near the right of way. So, you know, to reduce visual clutter, if the pole sign came down and a new monument sign was even put in, I would gather the monument sign would probably be set back a little further than the current sign is now.
That's correct. And also it depend on the size of the monument sign. But yes.
Yeah. Okay, cool. No big deal on that one. Any other questions for Jason? Okay. All right. Well, next up is the applicant. They've got up to 10 minutes to address the board to give the reasoning for their appeal to keep their pole sign. That must be Blake. And we'll have Bert give you the floor here, Blake. We just need your complete name and address.
Hi, can you hear me?
Yes, sir. Go ahead.
Great. This is Blake Johnson, EJF Limited. We're the owner of the building, and I'm located at 7100 East Bellevue Avenue in Greenwood Village, Colorado. Thank you, board chair and board, for your considerable time in considering our appeal for an exemption. We know I've listened to this. You guys put a lot of thought into all of these. So thanks a lot, and on a volunteer basis. So we're applying for an exemption based on a type 2 of this, and I'm going to address each one of the 2 points, A and B here. A, discontinuance of the use was due to a unique circumstance, not of the property's owner's own making. The loss of our sign was a very unique situation in that the property zoning was changed for our property to a C1 at some point. If you look at the property, it has a 3-bay garage in it for light auto repair. That's how it was built in 1970. That's what the zoning allowed. At some point, the zoning changed, and we did not know that. So we were sent notice in 2019 of the non-conforming use, and we wanted to appeal, but we couldn't find any prospective tenant that would pay the $7,000 to appeal the use and might likely lose it in talking with some city folks. So without the zoning change, we were faced with losing that part of the building, and our tenant, Advanced Auto, had to kick that tenant out, Advanced Auto Repair, who'd been there a long time. The son was running it. Anyway, so Advanced Auto vacated that because they didn't even know if they could use that part of the building. We were losing a part of our asset. Then in 2020 or in 2019, the zoning map was changed, as you all just referred to, and we got zoned MX3, but we had no idea as the owner. No information was sent to us. We were not notified of this. Now, MX3 allows for light auto repair use. We're thrilled we can finally use this, but we didn't find out about this until December 3rd of 2020. So this is way beyond the 6 months, and I don't know if the zoning change took over 6 months, but we had no way of knowing. So this was a very unique circumstance in that our zoning was changed to allow our building to use it. That pole sign is just for that space right there. So we believe proper notification should have been sent to us. I think if you're a building owner and our file is on record, our address, it's easy to find, our phone number. We've talked to the city inspectors many times. They're very helpful. But we had no idea. And we think there's a legal obligation of the city to inform us of a zoning change. I think if you change someone's zoning, they should certainly know. We appreciate it, but we feel like if we lose this pole sign because we weren't notified, we think we may have a claim in court. Although we hope to go through this board and remedy that here. Okay, so part B is the resumption will not have a significant adverse impact on the essential character of the surrounding neighborhood. You've seen 4 out of 5 neighbors have voted for it. The 5th neighbor is Maxwell Needham, and he's an auto repair facility. He has his own pole sign, and he's 300 yards away. and he competes with us for that same kind of business. So I would probably guess that would explain why he doesn't want to have competition or a sign. So it doesn't deter from the neighborhood. We believe if you put a monument sign up, it's going to cost a significant amount of money. And it's just another sign that you're going to have. So you're still going to have 3 signs. We're an industrial property. It's an auto repair and auto fixing facility. It's a highly commercial corner, fast food, cigarette across the street. They all have their own pole signs. You know, we cover an entire city block in length, over 250 feet. So we don't think there's clutter with 3 signs. Finally, we believe city should support its business. You know, we've invested significantly in this property since we purchased it from an out-of-state owner who was just trying to develop it into something else. We put in new roof, new HVAC, redid the sidewalks, brand new sidewalks out there. So we put considerable amount in there and new facade on there. So tearing down a sign and having to put up a $20,000, $40,000, $50,000 monument sign it's a remedy, but it tears away from our ability to invest in other things in the property. There's a lot of vagrancy in the neighborhood. We've had to put, we have to deal with that as well. And I sure appreciate Jafra personally. So thank you. So finally, also there's been a loss of a lot of retailers, Gorman's down the street, Kmart, and Kmart is now going to be a storage facility. Getting rid of and not supporting these businesses that add to a service to the neighborhood and bring people in, I think hurts and tears away from people. Thank you for your time and consideration. I'll yield the mic.
Okay, board members, we have some questions for Blake.
Hi, this is Lynn Carlson. I got a question. Does he have, or is there somebody doing auto repair from there now, or do you have a lease for somebody to go into that with auto repair, or do you need to find somebody once you get the sign back?
Thank you for your question. We have 4 interested parties. We just found out about this December, just last month that we allowed them. So we are waiting to get their sign as well as get them signed up. So we have many interested parties now that we know the zoning has changed.
Thank you.
All right. So Blake, I'm trying to connect some dots here with you. You keep talking about the zoning change and how bad that was for you. But the appeal in front of us here is to keep a pole sign. So even if the zoning changed, if you had a current use in there, that use would have been grandfathered through. So if Mel's Auto Repair had been in there as one of your tenants for 20 years and I'm still there, I could still be using my pole sign. So I'm trying to find the connection here. Why did you lose a tenant? Did someone close their doors or leave, or what happened that the site sat vacant for more than 6 months?
Mel, thanks for the question. We were sent a notice of from the inspector, Ian Donovan, who I'm guessing Sue Ann Donovan relation. I would love to find that out. Anyway, we got this a notice that we were facing a violation because the auto repair was not allowed under C1. Light auto use is grandfathered in.
And all right, and that C1 zoning district had been there for decades. Correct?
I honestly don't know.
Okay, yeah.
This was built in 1970. It's a 3-bay garage with lifts in it. It was never anything but auto repair. I can't tell you the history from 1970.
Yeah. So and I'm not here to debate this with you, but C1 are neighborhood-based businesses. So if that use was not allowed, there was no grandfathering. So, but nonetheless, the business closed. And so then the pole sign has sat vacant, correct?
Correct, but it was built by permit at some point. So it was certainly allowed at the time, or I don't know how you could have gotten 3-bay auto repair done there.
Right, but in any zoning district in the city, pole signs are now illegal for new construction. And in any zoning district, if the sign is not if the business is not in current occupancy, then after 6 months, that pole sign can't be grandfathered in. So we still arrive at the same conclusion. There hasn't been a legally operating business in there for more than enough time. So that's the reason that the city has brought this, or you brought your appeal forward, because you want to reuse the sign, correct?
Correct, but we were facing the law, a unique loss. We were going to lose the use of that part of that building. We were looking at having to basically gut it, destroy it. So you are correct. I mean, that's why we're here. It was vacant for 6 months, but we were trying to find a way to fight this appeal to allow that to be used. So we were, sort of miffed at how we could even use our facility, our asset anymore.
Okay, all right. Okay, any other questions for Blake? Okay, all right. Well, Blake, thank you for your comments. We'll see who else is in the audience here, and then we'll come back to you. Do we have any speakers in support of the request by the applicant?
I don't see any. There's nobody else besides Mr. Johnson.
Okay, and anybody in opposition or in neutrality?
Does not appear so.
Okay, all right. Sue Ann, do you have any comments for the board? Is Sue Ann available? You may be on mute if you're still here.
I am on mute. Thank you.
Okay.
Chair, members of the board, just to clear up one question that was asked, I am not a relation to Ian Donovan. He is an employee that happens to have the same last name.
Okay.
Thank you.
I'm not exactly sure of all of the happenings regarding use of the auto bay, and I don't know that that really plays in to what we're talking about today. If you boil it down to what the facts for consideration are, is that pole sign stood there unused for over a year with nothing in it, and therefore under the code it has to be removed. And I think that's the only thing that's before us. The notification of zoning changes, we did a wholesale rezoning and rewriting zoning map and rewriting the zoning ordinance. It was made public in numerous ways over at least a 3-year period of time. There is no way to mail notices of rezoning to every property owner in the city of Des Moines. So there was enough public outreach that was the way we did it. We did public outreach, we did news, we did all sorts of things. But really the use of that sign has very little to do with the zoning of the property. It has to do with actually putting in, using the sign face for some activity in the building. So in my opinion, the sign has to go away. There's no reason for it to be allowed to remain. As you know, as a board, City Council has been very interested and insistent on cleaning up pole signs in our neighborhoods and getting them removed. So I don't think we've met the test for an extension of the time for which the pole sign should be allowed to be reused.
Okay. All right. Do we have any questions then for Sue or the city staff from the board? Going once, going twice. Okay. All right. Well, Blake, you can wrap this up. You get the last say for testimony. You've got up to 3 minutes for any rebuttal or closing comments you'd like to make.
Thank you. Thank you, Sue Ann. To answer, I don't live in Des Moines. I don't get the Des Moines paper. So I have no way of knowing as an owner. Our company didn't. So there was no way of knowing for us the zoning change. There's nothing posted on our property or sent. So we did not know. This pole sign is specifically for under the lease with Advanced Auto for their tenant, the auto repair facility. So there was nothing, we could not have put another use on there legally within our lease. And that's just a commercial operation and contract law. The specific unique circumstance here is that our zoning changed, which we didn't know. If we'd have known sooner, we wouldn't have left it unused for 6 months. Again, we didn't find out until December of 2020, and here we are in the next exact meeting asking for this. So, and then again, there are pole signs. I know that they're not what everybody wants, but they do advertise a business. And if we start losing our advertising capabilities, it does hurt the business. Thank you. So thank you for your time.
Yeah. All right. Thank you, Blake. Okay. All right. Then we'll close the public portion and we will go to board deliberation. So folks, what do you think?
Hey, Mel, this is Dave.
Yeah, Dave.
I think it's super convenient that the owner thinks that we ought to be notifying him of zoning changes. He's got tenants in there. This wasn't a secret to anybody. If you're in the real estate business, I think it make it your business to know what's going on in the area. So that to me is not an acceptable excuse. I think it's clear that they've not met the requirement. I think there's a huge movement on to remove these pole signs, and if you're not in compliance, I don't think there's any middle ground. I think we just move on. Let's get the sign down, and if they need to make another decision based on that and that property, then I think that's certainly their prerogative. But
yep,
I don't think we need to spend a lot of time here reinventing the wheel.
Yep. Okay. Other
And
thoughts?
this is Marlis, and that's kind of on my beaten path from and to my house. And I have gotten so tired of seeing that pole sign with nothing in it. And I totally agree with Dave's comments.
All right. All right. Other thoughts? Okay. Okay. Yeah, this can sometimes be surprising for folks that, city ordinances change. I can't quote U.S. Supreme Court cases, but I believe that a citizen or a business cannot use a defense of nobody told me about a law, a rule, or an ordinance, especially a change in one, and therefore I didn't know that what I did was illegal, wrong, or not permitted. So it's appropriate for a property owner to understand zoning, building code, and certainly check for any changes if they're anticipating changes in use or activities on a property. This board has been pretty steadfast that the variance test is a high one, and pole signs are coming down in the city of Des Moines. City staff, in my opinion, can certainly work with the owner to let them know, as Jason Van Essen said, they have the ability to look at monument signs or on signs for buildings. So I kind of feel like sometimes you just got to say no and pull the plug on these things. So if anybody else has any other thoughts, or if not, would there be a motion? Dave or Marlis, you want to make a motion?
I'll make a motion.
All right, motion by Dave for staff rec. Is there a second?
I'll second.
Okay, all those in favor for denying the variance requests, we'll take roll call.
And denying the exception request?
Oh, I'm sorry, denying the exception request.
Cindy Smith,
Aye.
Marlis Jones,
Aye.
Justin Gross,
Sorry, aye.
Dave Gare,
Aye.
Lynn Carlson,
Aye.
and Mel Pins.
Aye.
That motion carries 6-0.
Blake, the city will send you that decision in order about a week from now. And after you get that, I'd encourage you to just sit down with city staff and talk through options for how you can reuse that property and how you can look at signing here under the current ordinance. All right. Okay. So this moves us on to minutes from the last meeting. I believe everybody was present at our December meeting. So if there are any changes anybody wants to note, please comment. If there are no changes, would there be a motion and a second to accept the minutes as presented?
I'll move, Mr. Chair, to accept the minutes as presented.
Motion by Cindy. And I'll go ahead and second that. Okay, so I got a motion and a second. All those in favor of approval of minutes, Tyler will read roll call.
Lynn Carlson,
Aye.
Dave Gare,
Aye.
Justin Gross,
Aye.
Marlis Jones,
Aye.
Cindy Smith,
Aye.
and Mel Pins.
Aye.
That motion carries 6-0.
Okay, now before we adjourn, and we haven't done this for a while, and I'll have Judy and staff help us here, but the Zoning Board of Adjustment can ask the City Council for consideration, review, or proposed changes in the city ordinance related to our purviews. So staff, could you maybe help us out with this? I know it was mentioned earlier that, well, maybe that floodway thing on the signage, yeah, that's maybe carries. Strict for signage.
Or this is Judy Parks. What your action would be making a motion and then asking the city council to consider this as a referral for revision of the floodplain signage provisions, which currently disallow any signage in that district.
Okay. And in that, we wouldn't have to get into great detail, but we could say something like, hey, we'd like to allow provision to allow signage, and the city could come up with comparable language based on the current use of the property for having some applicable signage allowance or something like that.
Something, yeah. And it might not also be a bad idea to indicate to them that you have had multiple cases with this particular situation coming before you.
Yeah. And aside from today, I can't recall how many we've had in the floodway that are signage related, but I'm assuming with the rezoning ordinance, we've expanded the amount of square acres or square miles in the city that are in these flood zones. Is that correct?
Yes.
Okay.
Chair, members of the board, this is Sue. I think this is the first one that's come before.
Yeah.
In reviewing sign permits in the office.
Yep.
Yeah, we had another item number 9 on today's agenda, which was for the exact same type of relief, but the applicant chose to withdraw their.
Okay.
Right.
Do you have some other new code cleanup, which you guys are going to be doing anyway in the next 6 months plus?
Yes.
Yes.
So if we put this request together, then you could just kind of slot that in with some other tweaking, and it wouldn't put city staff into any undue work or cost, would it?
There will be plenty of other things being tweaked. So yeah, it can be in the list.
I'm not saying
Okay.
it won't add, but it can be on the list.
Right. Yeah. But you could work that into a council agenda item that would in essence be quote cleaning up or fixing a few things here and there.
Yes.
Okay. All right. Well, colleagues, do you have some thoughts on this? Do you think this would be a good idea, especially after the case we had today?
This is Lynn Carlson. I think it's a great idea. Do we need to give some other reasoning besides the fact that we saw this case or we heard this case today, or would they maybe pull up the recording of this case and listen to our arguments and get an idea of why we're asking them to do this?
You know, I don't think it's going to be hard for them to figure out when you look at the amount of expansion of these areas, and to have absolutely no signage does seem a bit drastic.
Yeah.
The council, or at least the mayor, is also aware of this particular case and was told by staff that it would be reviewed. So this would just be supporting what has already been shared.
Yeah. Okay. Now, all right. But yeah, that's a good thought, Lynn. So if we just have the skeleton here, the staff can flesh this out, because I think the reasoning was probably pretty clear today, just in general, that again, you got a big shopping center or any other retail or reasonable properties, and suddenly they can't have any sign.
And if, Judy, correct me if I'm wrong, the variance approval goes to council to look at anyway, does it not?
No,
it doesn't?
It's not.
Only if it was liquor related, right?
If it was a separation distance requirement or a use variance, then it would.
All right, thanks for the correction.
No worries.
Okay, well, board members, we can certainly have more discussion, but I guess I'll just throw out here. I want to propose that, or I'm going to make a motion that the board would request the council's review of the applicable zoning ordinance chapter and statute here as related to disallowing reasonable signage within a floodplain for an existing use, and to amend that to allow for reasonable signage based on applicable and reasonable signage allowances for the type of use currently there, or something like that. Is that good enough?
Make it floodway and floodplain.
Floodway and floodplain, and the two are different. As a good DNR person, I know that. Yeah.
Okay. Just
Sure, I'll
to be
second
all
that.
inclusive.
Yeah. The floodway is where the water normally moves. The floodplain is where flooding can occur in a certain percentage.
Mr. Chair, I'll second that.
All right. So we got a motion by Mel, second by Justin. So Tyler, will you take us around the bend again?
Sure can. Cindy Smith,
Aye, please.
Marlis Jones,
Aye.
Justin Gross,
Aye.
Dave Gare,
Aye.
Lynn Carlson,
Aye.
and Mel Pins.
Aye.
Motion carries 6-0.
Okay. All right. Well, Bert, do we have any other business?
I believe that is everything for the day. So,
Okay. Well, colleagues and staff, yeah, I thank everybody for their time, and thanks for a good training session this morning.
Sure.
All right.
Great job, guys.
all right. Well, enjoy
Okay,
your
this hearing is formally adjourned. Have a good evening.
Thanks, everybody.